Okay. Good morning and welcome to the House Executive Departments and Administration Committee. Today is Thursday, January 29th, and I would like to ask Representative Thibeault to lead us in the Pledge of Allegiance. To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much. We have several bills on the calendar today, and we will start by opening the hearing on House Bill 1340, limiting occupational regulations to those demonstrably necessary to achieve public health, safety, or welfare objectives. And I'll recognize Representative Slotchie to introduce his bill.
Thank you, Madam Chair. And thank you, committee. I'm very happy today to present to you my name is Jeremy Slotchie. I represent Hillsborough 13. For the record, that is the town of Hudson. And I am very excited to present to you House Bill 1340. The intent or the purpose of this bill is to codify in law the concept that the purpose of licensure is not to be a barrier to the individual's right to work. We want licensure to guarantee that the folks who are employed in professions that have a public safety or health concern, that those are appropriately overseen by boards that enforce a standard of practice. But it's sort of the opposite of that. We don't want to create the circumstance where we allow guilds to form, where we can keep out the riffraff, those types of things. We want people in this state to be able to go out and to work. I very strongly feel that that's a very bipartisan, concept. And so I'm really excited to work with all of you to perfect and enhance this bill. And really what it does, there's a few, sort of core elements to this. The first is that it creates the concept of a fundamental right for individuals to pursue a chosen occupation. And to be free of arbitrary or excessive restrictions on that occupation. It limits regulations to those demonstrably necessary, and they must be tailored to either a public health, safety, or welfare objective. They're all defined within the bill. What I hope to achieve with this bill is to ensure that the citizens of the state have economic mobility, and the state isn't a barrier to people getting a job. And I know we've heard testimony on this committee, and I've spoken with many of you about seeing circumstances where we felt like people weren't able to achieve that. So I want that to be the core of the intent of this bill. Let's see. Yeah, the rest is details. So I'll end there. If you have questions, I'm happy to answer them. And I really appreciate your looking into this. Thank you.
Thank you. Are there questions from the committee? Representative Grota?
Thanks. Good morning.
Thank you.
So how is it that this would be sort of an umbrella? I see this as an umbrella or bill that would pertain to our licensing. Is that right?
That's correct.
Follow up?
Follow up.
So what is it in our licensing now that you feel that this is necessary? What hurdles do you see?
I'll give you an example of what I think might happen. What I wouldn't want licensing to be in any state is a vehicle for certain individuals to prevent access or to individuals who are otherwise qualified, or to use it as a vehicle to self-promote or self-enrich. So I definitely can think of at least one example where we've heard testimony about, I don't want to get too specific, but it would be very upsetting to me to encounter an individual who is using our licensure as a scheme to force otherwise qualified candidates to attend their seminars or courses, or to have to pay them in order to gain access to a profession for no other reason than their own enrichment, if that makes sense.
Thank you. Representative Long?
So I just want to get a better sense of how the bill works. So my pet example of this as a lawyer is that, I mean, law school absolutely is unnecessary when we have the bar exam, and it is essentially what you just mentioned, forcing people to pay money to members of the profession in order to join it. So would this, but there is a legitimate rationale for that. Well, there's a legitimate rationale for the bar exam that allegedly applies to law school too. So I guess, does somebody who wants to become a lawyer under this have the right to challenge the law school requirement in order to take the bar exam?
Yeah, and that's a great question. And thank you very much for asking it. I think there's a legitimate reason for public health or safety, an articulable reason in many professions that it would allow them to challenge it, but ultimately there needs to be a public safety or public health or some general welfare reason for the examination. It can't just be the reasoning cannot just be that we want people to attend law school. The reasoning has to be that the public would suffer otherwise, if that makes sense. So it's that the initial reasoning has to be solid before you can start making people attend school, I guess.
Representative DeRoy?
I'm over here.
Yeah.
Hi, how are you this morning?
Fantastic. Is that
Okay.
your question? That was
Yes,
an easy one.
That's the
Thank you.
question, yeah. Why wouldn't we do this for all professions? Why are we limiting to just this? I can see this happening to engineering and all kinds of different venues.
Thank you. Yeah, it's a fantastic question, and it's my understanding that this bill would apply to any licensed profession. So yeah, I didn't intend for it to be limited to any specific profession. It's just it's more about setting the standard of any licensure to be that of public safety, public health. These are the reasons why we license professions, and any other reason is not a good enough reason to issue licenses and maintain a sort of licensure regime.
Representative Dargy and then Representative Groda.
Yeah, thank you, Madam Chair. What do you think about borderline situations? Like going back to your comment about someone having a course on that someone has to pay to join the course. How do you decide whether that course really does meet the needs of society and not just provide income for that person? You know, presumably, if it gets into law, there is some sort of a rationale for requiring people to take that course. How do you make that decision, and how's that addressed in the bill?
That's a really great question. I thank you very much for asking it, and it's important. It's a difficult distinction to make. I tried to cover it in the sort of definitions of terms of what is the public interest. So there are definitions in the bill, but the idea is that in my opinion, the first examination is the person going to be performing a job function that has an impact on the public health, right? So that's to me, that's the sort of first step that you have to be able to justify, and then whether or not a course material adequately prepares someone to address the concerns you have. I would say that, in my opinion, that's up to the board. I would want a professional sort of, what would you call it? Someone who is a professional in the field to be able to make that determination. I wouldn't want to codify that into law. I'd want it to be a function of the board, if that makes sense. So.
Thank you. Representative Groda, you had another question?
Thank you. Who is responsible for making sure that this, who's responsible for this?
That's a very good question. In my intent, it would be OPLC would review and report. It's always our responsibility to make the final determination, right? And so in that sense, it would be either a court of law or us would be the responsible members. So if an individual challenges this in court, the court can make that determination. Or if OPLC reports to us and says, hey, we have this wacky license, we don't really think it serves the spirit of this law, take a look at it, we can certainly take action on it at that point.
And follow up?
Follow up, yes, thank you. There's no mention of boards,
Mhm.
and boards play an important element to licensing. So how would this interface with boards if there were a conflict?
So I think and thank you for the question. I would assume, and I may be incorrect, and I think it's very important to be able to get the wording right and to meet what I think the intent of your question is, and very open to discussion on that. My ideal would be that the existing law of how boards operate remains unchanged, and this provides a sort of separate avenue for individuals to challenge what they believe to be an unjust licensure of a profession that has no public impact. They can challenge that in court. Or that the bureaucracy of OPLC can say, hey, we're in the field. We don't feel like this is serving a public interest. Please take a look at it, legislature. Here's your report, type of thing. So the concept of the board would remain unaltered as long as the profession meets the what would you call it? The spirit of the law, that it has some public impact, like doctors, obviously, right? So.
And again, Representative Groda, another
Yes,
follow-up.
thank you. So we have an OPLC oversight committee.
Yep.
And how would this bill interact with that?
That's a great question. I don't feel I could give you a good answer. I'd love to know more about it. I'd love to speak with you on it. That's a great question.
Thank you. Other questions from the committee? Representative Schmidt?
Thank you, Madam Chair. Good morning, Representative. So this committee in the past has heard testimony where the allegation is made that that licenses are nothing more than a barrier to honest folk to get at certain professions, occupations, or whatever, that it's only a barrier, has no legitimate purpose. And we may hear that from some people who are here today, recognize some people who I think are practitioners, where the public safety, you've been kind enough to reference public health a number of times, but public safety is an equal responsibility, I believe. And to the degree that you kind of put more and more barriers to clear procedures, it kind of gums up the works. Isn't this, has the potential to be a procedure to prevent flying pink elephants, to give an example?
Sorry, could you clarify the specific question within that?
I think I made the point. Representative Slotchi is a highly intelligent individual. We've seen that for a long time. I think he can discern the point of my question.
I think so. And thank you very much for the question. I think I can lay out what my beliefs are, and I think that I have an inkling that I share these beliefs with a lot of the members on the board, if not everyone, or the committee. But the idea of licensure is sort of two things. It sets the minimum standard by which we expect anyone in a profession to be able to operate when that profession has a impact on public health, safety, and all of the great things you mentioned. And it's a mechanism by which the state can ensure that sort of ongoing good behavior, right? If people are continuing to meet that minimum standard on an ongoing basis, it's as long as those two things are being met, I think licensing is working as designed and as we would all want it to work. And so the whole point of putting forward this legislation is to sort of just codify into law that those are our expectations, those are our standards, and provide a mechanism when those standards, someone feels that those standards are being met, here's the mechanism to redress your grievances, if you will. Does that answer your question?
Well, that helps, and of course you realize that your testimony is on the record, and helps the court, if it ever came to that, the court to define where the legislature's intent is going in terms of preventing. There's a word that's escaping me at the moment, but arbitrary is something in that direction. That it goes as far in the wrong direction as the hypothesis from the other side is that there is currently a barrier for the barrier's sake. We don't want such people coming before, and this is a way of banning people who shouldn't be barred from from participating. And it's a very fine line, as that's where you've been going with your testimony, that it's a balancing act.
I
So
agree
thank
with you. Yeah, thank you very much.
Thank you. I have a question for you. In your definition of welfare, it says welfare shall be narrowly construed to encompass protection of members of the public against fraud or harm. In your understanding of that, would that be things like ensuring that court records are kept accurately and that would protect people from fraud or harm? Or is that something that you would see as outside of those requirements?
If court records are kept accurately,
Yes.
if you can articulate a reason that them being not kept accurately would be detrimental to someone's well-being, and I think that you could make that case, then yeah, I mean, I think the legislation says that any sort of licensed profession must meet these standards, but I can imagine there's many scenarios in which unlicensed professions also meet that standard. This is, in my opinion, this legislation works to say that if we are going to license, you must clear this hurdle. So it is. Does that catch the spirit of your question?
It does.
Okay.
It does. Thank you. Representative Pearson?
Thank you, Madam Chair. So we've had a lot of talk about the state here, except that your definition of agency includes counties, cities, towns, political subdivisions, branches or department divisions of office, with the ability to file action in Superior Court after 90 days. So if someone doesn't like that the town of Derry licenses barbers or cosmetologists, they can go through this process, or massage parlors or anything else that the town specifically regulates, then, because this isn't just a state level thing, you've run this all the way down to the lowest level of government.
Yeah, that's true. Yeah, I think as the lowest level government is a subdivision of the state, I tend not to recognize the difference, but certainly if a town is being heavy-handed with a specific trade, I think it's the purpose of government to regulate these sort of industries that have a public health interest, but also it's very clear in the United States Constitution all the way down that the individual has the right to seek justice for any sort of grievance that they have, even if those grievances are illegitimate. The redress of grievances is a core function of government. So yes, I agree with you. That is the purpose, and it's to give people who feel aggrieved a pathway, even if they are not legitimately aggrieved. There ought to be some measure or process that allows them to at least have their day in court.
Follow up? Do we not have that process right now?
That's a good question. There are appeals processes, it's sort of administrative, but I'm not sure that there's I'm not sure actually if New Hampshire has a right of action for individuals who feel they've been aggrieved by the administrative process. So I don't know. So glad.
Thank you. Representative Sellers?
Thank you, Madam Chair. Representative, is this really aimed towards like, I want to be a hairdresser and I work out of my house and I just have my friends and family over? Is this what this is aimed at? Because normally a hairdresser needs a license.
I don't think it's aimed at any profession in particular. So it's more just setting the standard of expectation in law of what the purpose of licensure is about, in my opinion. The purpose of licensure is to protect general public health, and in any circumstance, in any profession, if we find that folks are setting up little fiefdoms for no other reason than that either they feel like it or they're looking to enrich themselves, that isn't a legitimate function of licensure, and that it should be at least evaluated by courts or evaluated by the legislature.
Do you have a follow-up?
Thank you, Madam Chair. I'm just trying to figure out because of our Constitution, and we should have a right to make a living without any licensures, especially if I'm working out of my own property, my own house. I'm saying is that's what I'm trying to figure out, if this is what that's trying to protect. And I'm not just saying one profession, I'm saying technically anything. If I want to tell someone how to build a bridge or to cut their hair or to whatever, to learn how to drive.
I mean, technically anything. It's just there. It isn't so much about where or when. It's is there a public interest in health and safety or not? Is the hurdle I'm trying to make sure that we're meeting with any licensure scheme. So whether you're a hairdresser at home, if you can articulate and convince a reasonable, judge that, hey, this isn't in the public interest to regulate my trade, then this law would give you a mechanism to seek redress of your grievance.
Representative Groda?
Thanks. So I'm from what I understand, you are amenable to an amendment.
Yes.
And might you entertain reducing the scope? And because we've talked about this,
Oh yeah.
right? And I just want to make sure that whatever is enacted is something that is doable and that we just don't have this free-for-all for interpretation, because what the general court puts into law is vitally important. So I'm glad that you're open to that.
Absolutely, and I thank you for all the input. That I'm sure we're going to have discussions on this, and you're correct. It's vitally important that what we put into law is meets the intent. So I think I've spent more time talking about my intent rather than the specific wording of the legislation, and I think it's important that we work together to ensure that what we end up doing, if we do anything, is appropriate and correct and won't cause more headaches than we solve.
Thank you very much. Are there other questions from the committee? Seeing none, thank you very much.
Thank you.
Next, I'll call Megan Heffler from the New Hampshire Court Reporters Association. Were you both looking to come up together? Okay, yes. I was trying to stack 4 against 4 against.
Hey, good morning.
Good morning. You can introduce yourselves.
Yep.
We do a 3-minute timer. Since there's both of you, you'll get the 6 between the 2 of you.
Thank you so much.
You're welcome.
Hi, I'm Megan Heffler. I am a New Hampshire licensed court reporter, number 61. I am here on behalf of the New Hampshire Court Reporters Association, as is my colleague Catherine Sweeney, the current president of the association. A little bit about myself. I reside in Northampton, New Hampshire. This month is my 30th year there, and so happy to be living in New Hampshire. So that's my little bio. I want to talk about this bill, and Catherine's going to take a different part of it than I am. This bill is presented as cost neutral. Unless somebody's offered up a fiscal note, I haven't seen it. That does not mean there's no cost, though. It means unknown cost. Unknown, and that matters. This bill shifts the burden of reviewing and justifying existing regulations onto agencies and the courts. That means more legal review, more staff time, and likely more litigation. Those costs do not disappear. They land on the DOJ, the Department of Justice, the court system, and ultimately the taxpayers. In effect, this bill outsources regulatory review to lawsuits and pretends that process is free. It is not. Catherine and I know this intimately. Litigation is expensive. It is how we make a living. Before creating a new, retroactive legal standard that invites court challenges, this body should have a clear, quantified understanding of the fiscal impact. And right now, you do not. This bill introduces uncertainty into a system that functions well, really well. There is no New Hampshire problem that this bill fixes. This is a solution, shopping for a problem, and it has picked the wrong aisle. This bill replaces clear standards with case-by-case litigation. and I respectfully urge you to vote ITL. Thank you. And if you'd like to hear from Catherine.
Yes, if you could introduce yourself, Catherine.
I'm just going to switch so I'm in front of the
Yes.
microphone.
That does make it easier.
Good morning, everyone. Happy to be here. My name is Catherine Sweeney. As Megan mentioned, I am the president of the New Hampshire Court Reporters Association, and I am proud licensed court reporter number 166. I'm here to speak about HB 1340 and the effect deregulation would have on not only stenographers and attorneys in the state, but most importantly, the public welfare of the litigants. Court reporters take down the words of everyone in the room, but we also ensure the personally identifiable information of those who testify is protected and remains confidential. Things like social security numbers, banking institution and account numbers, medical information, including doctors and medications, are very often testified to at depositions. It is up to us to guard the information and ensure that it is kept safe and not disclosed to unauthorized individuals. We follow a code of professional ethics. They are strict and include things like impartiality, competence, and integrity. As part of New Hampshire licensing, we agreed to abide by this code of ethics, which ensures that sensitive information is not improperly disclosed and that the public can trust that we will act ethically and professionally. Court reporters love our licensure because it proves to the people who want to hire us that we are competent, capable, and trustworthy. The license granted to us through the New Hampshire OPLC gives us the privilege to work in this state and show that we are worthy to uphold this state's laws and rules. If licensing of court reporters is taken away, there is going to be zero oversight of who will be responsible for taking testimony and making sure the personal information of its citizens remains private. Worse yet, anyone can just walk into a deposition, call themselves a court reporter, slap a tape recorder on the table, and send that recording off to other countries, to the web, to the cloud, to get transcribed, sent to someone who has no training on preparing a transcript, who doesn't understand legal or medical terms, has no ethical standards to follow, and who is now privy to all sorts of private information. The litigants, the actual consumers of the judicial system, are going to be harmed by the potential impact of devalued services from unlicensed and unregulated people. By having the current minimum standards in place in New Hampshire and providing oversight, continued licensing of court reporters will help maintain the quality and integrity of court proceedings, which is essential for upholding justice and protecting the rights of citizens. We welcome more stenographers in New Hampshire, but the only way to be assured the public welfare would not suffer is through licensure. Thank you for your time.
Thank you. Representative Long?
When someone takes a deposition, how does the court reporter transcribing it get chosen?
That's a great question. The individual attorneys call usually agencies or they refer to the OPLC list. And I also run an agency. I'm in Bedford, New Hampshire. My agency only uses licensed court reporters. So having that licensure standard as a minimum, you know you're going to get competence in someone who follows the ethics.
Follow up?
Follow up. So if it's the litigants themselves or their attorneys choosing the court reporter, why would they choose an incompetent person in the absence of a licensing requirement?
They will only know the incompetence after the fact. When they receive a transcript that is not up to standard, they won't know unless there's those LCR letters after our name that we've already met the standards. You want to pull just somebody off the street, you have no idea about their competence.
My apologies. That was part of the testimony.
I
Nothing to do with the
understand.
question in that.
Thank you.
Another follow-up?
So, I mean, why is it not possible for them to talk amongst themselves, to review court reporters, all the things we do? I mean, restaurants have Yelp reviews. Why can't you do that with a court reporter who screws it up? Especially since it's already recorded, so you can compare their work to the recording.
So it is not recorded. We actually use steno machines and voice writers use their voice, but those recordings are not made public or not disseminated. They're not given out. They're destroyed most of the time after. I destroy mine after a deposition has been finalized. So it doesn't get into the wrong hands. So it doesn't go up to the cloud and just be accessible by storage, archival facilities and such. And I'm sorry, I forget the first part of the question because I had an answer to that.
So why do people?
Oh, Yelp, you mentioned,
Not-
I apologize, sir. You mentioned Yelp. I've been in business for over 25 years. I don't have any Yelp reviews. Nobody has ever done that for me. That'd be interesting. And sure, it would shore up my competence. But at a baseline, litigants are not talking to each other about who to hire for a court reporter. And attorneys are, but they're also just going to the list.
Thank you. Would you say that what you do in protecting that information is protecting against fraud?
Absolutely.
Thank you. And as a follow-up, it does say that one of the reasons for licensure is to protect against fraud. So
Yes.
as I read this, it would not. I don't see this impacting court reporters.
It's protecting the litigants. We are the person who is protecting the litigants from fraud, from their welfare.
Yes. Thank you. There are other questions from the committee? Representative Schmidt?
Thank you, Madam Chair. So I have this is a concern that the committee clearly has. I have, and I mentioned it in my questioning of Representative Slotry, that the system is already under stress, as you know, just by the pure demands on the courts and inadequacy of the system to have enough people. It's like a traffic jam.
Absolutely.
Sometimes the roads are fine. Sometimes they're empty, like during COVID. Sometimes they're jammed and the traffic comes to a halt because of an accident or just the sheer volume. And you can't have an eight-lane highway. So what I'm concerned about is the gumming up the works is the phrase that I use, and that's what I'm afraid of, because it seems to me that at the very least this legislation, if not being an invitation to complaints and lawsuits, is at least it kind of like a waving hand as you drive by, or a sign on the road, stop here. So do you fear things along that line as well? Because your testimony suggested that to me.
Yeah, and Megan spoke very eloquently about that, the invitation to more litigation and gumming up the system, as you mentioned.
Thank you. Are there other questions from the committee? Seeing none, thank you very much.
Thank you.
Next, I'll call up Jamie Kavanaugh. If you push the red means go in this committee.
Thank you.
Thank you.
Thank you, Madam Chair, members of the committee. My name is Jamie Kavanaugh. I'm here on behalf of Pacific Legal Foundation. We're a public interest nonprofit. We work in all 50 states, even though Pacific's in our name. We protect Americans from government overreach and abuse, both in courtrooms and in state houses. I'm a member of the policy team, so I work with state legislators like yourselves all around the country to improve laws. But I was a litigator in the past for 11 years, and that included lawsuits challenging occupational licenses directly. So I think I can speak a little bit to some of the questions that came up earlier. One of the questions I think was from Representative Pearson about if there is a cause of action already to challenge any type of occupational license or regulation. And the short answer is yes, in most states and at the federal level, there is a right. But the case law in this area is so bad for plaintiffs that there might as well not be a right. It's very, very, very hard to win a case challenging an occupational restriction or license because at the highest level, the U.S. Supreme Court has kind of written the right to earn a living out of the Constitution, has not taken that right seriously, even though it was something our founding fathers cared very much about and, is essential to a free society, the right to earn a living. So that is protected by the Constitution. It has not historically been protected very well by the courts. That's why this bill contains an important provision that does create a cause of action and gives the court, some guidelines as to how to review a challenged license that comes before the court. And Another question that came up, I think, from Rep. Darji was about how do the courts make these determinations? Like, who decides if something's really necessary for public health or safety? And one thing that this bill does is it asks, if a court is considering a license and it's a gray area, it asks, is there a way with less regulation to accomplish the same thing? So, you know, for an example, licenses look very different across states. You might look at a license for something like an auctioneer. I don't know if you have that in New Hampshire, but many states do. And you might say, what is our training requirement compared to other states? If ours is 500 hours and other states is 5 hours, we might wonder why we're imposing so much more, restriction, and if it'd be reasonable to maybe regulate with less of a heavy hand. So it's not an all or nothing that every time a license will stand or fall. I think that there might be some fine tuning of the requirements for a license. And then the last thing I wanted to say is that some other states already have passed this Right to Earn a Living Act, and they have not seen this flood in the courtroom of litigants. It's still hard to file a lawsuit. It's still expensive to file a lawsuit. That just hasn't come to pass in the states like Arizona and Louisiana that have already enacted a version of this act.
Thank you very much. That was very helpful testimony. Are there questions from Representative Long?
So you may not know the specifics of New Hampshire, but being a lawyer, I hope you can answer this question. So if someone does bring a challenge and say takes it to the New Hampshire Supreme Court, and the court ultimately decides this is not a valid challenge to this occupational licensing requirement, would the Superior Court then be required to honor that decision if someone else were to bring the same challenge in the future?
Yes, exactly. So if once the New Hampshire Supreme Court, opines, issues an opinion on an issue, that is binding for everyone else. So if there was a decision about cosmetology or landscape design or whatever it is, that would be binding on everyone in that field.
Thank you. Other questions? Representative Darji?
You mentioned, thank you, Madam Chair. You mentioned that similar laws are available in other states. Could you expand on that? Is it just the two that you cited, or is this common?
I believe it's more than the two, but I'm sorry, I can follow up with the committee. I don't have the list offhand, but I know for sure that Arizona and Louisiana have a version of this, and have for a few years. It's something more new because I think that people are frustrated by the judicial system's lack of accountability in this area, and so the legislature has an important role to play here too in protecting the right to earn a living.
Thank you. Representative Schmidt?
Thank you, Madam Chair. So how long have the laws been in effect in the states that you referenced? Is this something that has a long track record of successful implementation of good public policy, or is it something that's relatively new, so any negative effects have not yet been seen?
Thank you for the question. These laws are relatively new, maybe in the last 5-6 years, I would say, that we've seen them. But it's not that they were all passed in 2025. There have been, some years.
Thank you. So can you tell us whether you have written testimony and you're going to provide the committee, because your background is impressive, but I didn't catch it as you went through your initial introduction. I'd like to know where you come from.
Sure. I submitted written testimony already. I could supplement it because I didn't include some of the things we just discussed.
I'll look for your written testimony. Thank you.
Great.
Thank you. So this is placed in the Administrative Procedure Act. So this is around the purpose of rules. I don't know if this is if this is an appropriate question for you or not, but in the process of approving rules, we need to have a foundation for an objection. So if we're not actually fulfilling the purpose of rules, do you see this as a place to object to the administrative rules when they are being put into place, as well as a legal challenge? Or is this something that maybe I should ask somebody from administrative rules?
I think it's possible what you're asking about. I think it's possible that if a rule goes far beyond what kind of the statute envisioned for regulation of an occupation, then someone in that occupation would be able to use this cause of action to challenge that rule and say there's no, as long as they can make the argument that there's no connection to public health and safety.
Thank you. Other questions from the committee? Representative Schmidt?
You bring up administrative rules and the possibility of far exceeding. Would you believe that New Hampshire has a specific entity for proofing rules and that it's one of its specific functions is to determine whether a rule exceeds legislative authority, in which case the rule cannot be approved? Are you aware of that?
I was not aware of that. That's a great tool, but I'm sure there's still some instances where there might be a disagreement about whether it's overreach or not, and that's the appropriate place for a court to weigh in on that.
Thank you.
Thank you. Are there other questions from the committee? Seeing none, thank you very much.
Thank you.
Next, I'll call up Sarah Scott.
Good morning, Madam Chair and members of the committee. Thank you for the opportunity to testify here today. My name is Sarah Scott, and I'm the Deputy State Director for Americans for Prosperity here in New Hampshire. I'm going to skip a lot of what I had planned to say because I think it's already been covered really well. But one thing I really wanted to highlight is that initially, occupational licensure was intended to protect public health and safety in a number of these high-risk professions. And over time, licensing has really expanded nationally into a very broad array of occupations. So in the 1950s, I think it was about 5% of American workers were needing a government license to do their job. Today, that number is more than 1 in 5 workers nationwide. And there was a recent 2025 state occupational licensing index that showed just how much licensing varies from different states. And New Hampshire is actually about middle of the pack. I know we've made a lot of really good progress on getting rid of a lot of these occupational licensures that we've determined are not relative to public safety, but I think we still have a long ways to go. So in a state like New Hampshire, where you look at, according to this study that was done, a lot of the states surrounding us actually have a higher ranking in terms of occupational licensing than we do here in New Hampshire. So I think this is really an opportunity for us to set a standard moving forward, that while other parts of the country might be continuing to grow and increase their number of occupational licenses, I think this brings us back to a point where moving forward, we know that there are going to continue to be new licenses proposed. And so this sets that standard of where New Hampshire is going to go and the direction we're going to have. So we want to remain competitive with the states around us. Obviously, we don't want people all heading down to Massachusetts or across the border to Maine. We want to be able to keep that talent here in New Hampshire. So I think that this kind of legislation really provides that clarity and helps people understand that they're not going to face undue burdens just to have their occupational license here in New Hampshire versus any of the states around us. I just wanted to bring up, too, that the bill here doesn't eliminate any occupational licenses. So we're not saying today by passing this legislation, every license is null and void and we're starting over from scratch. This really just provides that clarity and lets people know moving forward that if government restricts somebody's right to earn a living, there should be some kind of a way to demonstrate that that restriction is necessary for public health and safety. I think we've heard good examples here this morning of how this legislation would impact some licenses that currently exist. And it sounds like, for the most part, a lot of these current things that have been licensed wouldn't be impacted at all. But I think this is really a good standard to have moving forward. While I might appreciate the current legislature and our attitudes on this, we can't always speak for what future legislatures might do. So I think this sets us up for a long-term success in that area. So ultimately, we ask that you support this legislation, and I'm happy to take questions.
Right at 3 minutes. Great. Impressive. Thank you. Representative Groda?
Thank you. Are you familiar with the Institute for Justice?
Yes, I am.
Are you familiar with their presentation that they made to this committee regarding their information about a licensing?
I'm not aware of the presentation they gave this committee, but I have heard presentations from them in the past.
Okay, so I'd like to know, when you say we're in the middle of the pack, where that data comes from.
So that was from the 2025 State Occupational Licensing Index. I can send you a copy of that if that's helpful.
Could you send that to us, please?
Yeah, for sure.
And follow up. When you say we have a long way to go, What do you mean by that?
Just, I would say, from my perspective, growing up in New Hampshire, I always want New Hampshire to be number one. I want, whenever these rankings come out saying where's the best state to live or raise a family or work, I want New Hampshire to be at the top of that list. So I would say we have a long ways to go in terms of right now for occupational licensing, we are middle of the pack. So I would like to see us up there being competitive with the states around us in particular. I'd like for us in particular to be number one for New England. I really hate when people can say nice things about all the surrounding states here. I like to be able to brag about New Hampshire.
Thank you. Representative Schmidt?
Thank you. So, as you know, the procedure for determining whether something is yay or nay, to put it succinctly, and that's going to be determined by a court to a higher degree than currently under this procedure. Courts are a matter of human judgment. The judge is going to make that final determination, but that's almost always subject to appeal, and appeals frequently result in an overturning of the lower court's decision. So aren't we getting into a situation where it's not a flip of a coin, but it's which judge you get? You get a good judge, you get a bad judge, you get an experienced judge, you get an inexperienced judge, and therefore it comes down to a flip of a coin in reality. So don't you foresee a probability that we're going to see a lot more litigation and a lot more delay in terms of determining whether a law is good or a procedure is good?
Thank you for the question. I think you do raise a good point, and I think this is something that we face in all aspects of law, really. I'll say I'm not a lawyer, but from what I do know of people who practice law, this is continuing in every aspect of law. There are appeals no matter what the area is, so I do think, sure, there is a possibility of that. I don't think it's something that's been seen in other states, but I would say that that's how our judicial system operates, and it does so in other aspects of law, not just for this bill in particular.
Thank you. Are there other questions? Seeing none, thank you. Next, I'll call up, thank you very much for the testimony. I'll call up Executive Director Deanna Juris from OPLC. And if you'd like, if you have a card for this one as well, if you want to pass it up as well, I'll be able to call you.
Good morning, Madam Chair, members of the committee. Just for the record, Deanna Juris, Executive Director, OPLC. I just wanted to very briefly state, and then I'm happy to answer any questions. A year is a very short time to do the review of the number of regulations that the OPLC manages. I mean, you figure if on average we're talking about 7 chapters of rules for 61 professions, that's pretty extensive. Yeah, I think a year would be a very, very short time frame to do this level of review and specificity. So I would respectfully request, it seems like an amendment possibly might be coming, maybe breaking it into chunks or extending a timeline or a rolling basis, some kind of opportunity. I understand that we don't want things open-ended, right? Deadlines are important to get the work done. We would be challenged to meet a statutory deadline of a year from that passing. So that would just be my one comment, not on the policy, but just on the mechanics of it. Other than that, don't take any position specifically, but I'm happy to take any questions.
Thank you, Representative Pearson, and then we'll move up this way.
How many people would you have to hire in order to meet the deadline?
Well, I only have so many positions, so it wouldn't be a number of hiring. I might consider potentially finding some legal interns or other interns. Otherwise, it would just have to become a priority, right? I'd pull people off of other projects that we're working on, and it would be all hands on deck for the summer.
No, I'm not asking you to restructure. How many positions, how many people would you have to hire to fulfill this requirement?
I couldn't quantify that for you in this moment. I could take it back and try to calculate some hours. Yeah, it would be a very rough estimate, but I could come up with something, but not in this moment.
Thank you, Representative Schmidt, and then Representative Long.
Thank you, Madam Chair. I would like to follow up right away with regard to Representative Pearson's question. I understand that you can't tell us how many, but do you anticipate that it would require additional personnel in any case?
I don't know if I can answer that directly, yes or no. I think it would mean a significant reprioritization of the workload that the office holds. There is not currently any, boards are working on rules as it comes up, but it's not a full-scale review of every sentence in a moment's notice. So we would be reprioritizing a number of things. So I don't know that I could say I would definitely hire more people, but it would take a substantial amount of work. Not based on, and I'm not trying to make a statement on the merit of whether it should or shouldn't happen. This would be a lot of work.
Thank you. Follow up.
Thank you.
So my original question was whether you see a situation where the boards are currently under a lot of duress with regard to citizens appealing to the boards with regard to the kind of underlying evil, if you will, that this bill is designed to prevent or limit. Do you feel that that our boards and our licensees are exercising an undue oppressive impact on the citizens' right to get a license or a right to work as it's been described here this morning?
I think you've asked me to make a bunch of value statements, which I will try to refrain from doing. What I will say objectively is there are a lot of rules, there are a lot of regulations, and as it was the statutory scheme, and then with any rule, things, they tend to grow over time. Things get added on. I think the existing process, well, you're going to hear a lot more today about the administrative rules process in that committee. There is a lot of process for implementing new regulations. You may or may not hear me saying, please, we don't need more admin. We don't need more steps in this process. It is extensive. And I will say there is a check and balance that already exists. I'm kind of pivoting away from your question a bit, but to give some context that when any entity, a state agency, whether it's a department, an office, a board, when they're making rules, there are teams of attorneys that work for you all that can and have said, I mean, you can see it, it's in public comment, there's no statutory authority for this, right? You can't do it. You can't include it in this proposal. We won't send it along. And then that feedback gets funneled back to boards. And so we're making those assessments. We also are making some recommendations. You guys have seen a number of cleanup bills over the years. We have a few more coming through, thankfully fewer and fewer, where we'll be in rulemaking with a board. The office obviously supports boards in that endeavor. And a proposal will go through and a comment will say that this law was repealed. You can't do rules on that anymore. Or this law conflicts with this other one that says notwithstanding. So you can't make rules on that anymore. So there are a lot of checks and balances that exist. So there is some existing structure there. The other point I wanted to reference is you had asked, are we getting bombarded with people asking or saying they're being oppressed? I would say rules they're designed to fit the mean, right? It's in some ways it's to set the minimum standard, or it's based on kind of the average, the normal, the one, like you can only have one set of rules, right? So we're regularly receiving requests for waivers. Often they are granted, they just don't fit into the cookie cutter of that mold. I would say that's a very regular occurrence. That's why we have a waiver provision. It could be something as simple as the reciprocity, the endorsement is substantially similar, right? So we set requirements in rule, but say the requirement is your state has to have 1,000 hours of training in their regs to be substantially similar. And an individual says, listen, my state only requires 1,000, but I did 1,500 myself. So I don't qualify for endorsement because my state didn't say it, but I meet your state wants, can you waive this rule for me? I've been working for 5 years and I actually met the requirement. That's something we typically would grant. And so there's so many unique circumstances, right? For every license, it's all these unique people. So we're regularly receiving requests to say, hey, this rule doesn't apply to me, or it shouldn't for X, Y, and Z reason. And if it's a PLC rule, that decision comes up through the office and often to my desk. If it's a board rule, it goes to the board and they can make that value judgment. So I would say that is a fairly regular occurrence.
One more.
As long as you keep it short.
Thank you.
please.
So would you say that the JELCR process is working well in New Hampshire with regard to making sure that the rules that are adopted by our agencies are fair and according to statute?
That seems like a value judgment question.
Well, I'll leave it out there. I've served on the JELCR for 20 years, so I've seen it pretty meticulously. Thank you.
I think there is extensive process and oversight. That's what I will say.
Representative Long?
Under current law, if the members of a board decide to act in their own financial interests instead of in the public interest, who actually has the enforcement power to correct that, and how is that enforced?
I don't want to speak definitively as a non-attorney and also as a person who's not in charge of ethics in that way. I will say,
And actually, I will say that's really outside of the scope of this bill. I think that's probably a good one to try and get answered, but I think it's outside of the scope of the bill.
okay.
Yes. Oh, you don't think it is? Oh,
I think that goes.
oh, can you turn your microphone on?
I think that goes to the heart of this bill, is that if somebody wants to say, you know, you have to go to my school of barbering or whatever, and pay a bunch of money to do that, what's to stop a board from doing that now?
Thank you for clarifying that.
I can just add some context. I'll just state some other things not specific to that question. So, the vast majority of board members on OPLC licensing boards are appointed by the governor and executive council. So there is a check and balance there where they have to be confirmed. So if there was a concern with a specific board member, it could be brought to that body or the nominating body, or in any case, actually, whoever the nomination or the confirmation entity is, it could be addressed that way. They are also considered executive branch officials, and so there are specific ethics codes that people are obligated to abide by, and there are complaint processes for any executive branch official. A complaint could be filed. So I am just speaking very generally that those things do exist. The other piece is that board members are obligated to declare conflicts. That's already a statutory requirement. So there's that piece there. So that's just generally what I will say.
Thank you. Representative Dargy?
Thank you, Madam Chair. Do you have a position on this bill, for or against or neutral? And do you have any, if it's neutral, do you have any specific concerns about any individual aspect of the bill other than the 1 year time frame that you already mentioned?
The office is not taking a position on the bill. I would say it's a policy decision the legislature should make, right? I just do what you tell me. If you put it in law, I do my best to do it. So I do think I really do try to keep it to operations and mechanics. I don't know that I could get you a report on every single regulation within a year. So that's my my current pause. Yeah.
Thank you. Are there other questions from the committee? Thank you for providing that information. It was very helpful. And next I'll call up Douglas Osterhope from the Administrative Rules effort, part of Office of Legislative Services. Too many abbreviations. You'll catch me on that again. And since I believe that you're up here to respond to some of the questions that we raised, I'm not going to start a timer since you're pretty much up here to answer those questions.
Yeah, well, so good morning. Thank you for letting me speak. I actually hadn't seen the language of this bill today, and so I didn't.
So could you just introduce yourself?
Oh,
before you
sorry,
start?
Douglas Oster. I am the director of the Division of Administrative Rules for the Office of Legislative Services. So, what I do, what my team does, is provide legal counsel. We are the legal review for the JELCR before the committee weighs in on administrative rules. I saw this bill for the first time today. My concern, not a policy thing, but I do see that it amends 541A, and I don't know if there's going to be an amendment, but I do have just mechanical procedural concerns. I see on page I guess it's page 1 or 2. Let's call it page 1. There's a new definition of agency. I believe that's already defined in 541A1. There's a definition there. Just things like, what else am I looking at? On the next page or 2 pages later, notwithstanding any, I'm on page 3, any other provision of law, any person may petition an agency to repeal or modify any occupational regulations within its jurisdiction. 541A4 already has language that allows any individual to petition any agency for rulemaking, repeals, modifications, whatever it may be, at any time for any reason. So there seems to be some overlap there. And again, I just saw this language this morning for the first time, so I haven't done a deep dive into it, but there's also floating in the back of my mind from a past life, 332G, which deals with a lot of occupational boards, I believe, and then, of course, RSA 310, which is the OPLC practicing statute. So really what I wanted to do is come up here and say, I think if the committee decides to move forward from a policy standpoint, we get an opportunity to take a look and make sure all the statutes are working well together.
Thank you. That's very helpful. You have a question, Representative Sitek?
H-A-U-D-T?
H-O-U-D-T.
O-U-D-T.
Yes, sir.
Representative Schmidt, did you have a question?
Thank you. So, do you see a flood of complaints with regard to unfairness of rules and so forth currently before your office in your time as a director?
Thank you for the question, Representative. I think predominantly they probably go to the agencies. Come on, Dee. I think predominantly they would go to the agencies. Occasionally, members of the public or of the legislature do reach out to our staff if they have concerns, and then we help them best we can. And whether it's we give them answers or we point them in the right direction. But I have seen it happen on occasion. It's not a very frequent thing.
Thank you. Are there any other questions?
Can I add to that?
Yes.
And typically it's the concern is around a proposed rule, not necessarily a rule already in effect.
That happen. I know that. That happens all the time. That's the purpose of the public policy review by the public hearing.
Thank you very much. We appreciate the testimony. And with that, seeing nobody else to testify on House Bill, I will close the public hearing on House Bill 1340. I'm just going to shuffle around my papers because I will be handing over my gavel to introduce the next 2 bills this morning.
Pumpkin at 11:30.
At 11:30?
AM or PM? That would be AM, right?
Yes, that would be AM. So we'll pass these over this way. This. Okay, as I relocate, and move this one this way. I'll get you my pink cards.
If you can, I got to step out at 11:30. So if you want to take it over, we can give it a go. I don't see any. So.
No, not yet. She's in.
All right. I'll open this hearing on HB 1312 and call the prime sponsor, Erica Lamb.
Thank you very much. For the record, I am Representative Erica Leon, representing Rockingham 13, the town of Derry, and I'm here to introduce House Bill 1312 relative to the authority of various boards. As Vice Chairman of the Joint Legislative Committee on Administrative Rules, I am here with a bill to update some of the things that we noticed during the process of rulemaking over the last year. There's the idea of establishing subcommittees. GELCAR has worked quite a bit with different subcommittees and the ability and authorization to do those, either adding them through statutes here in this committee, removing them through statutes in this committee. And this bill would allow a process to have subcommittees authorized. I do have an amendment that was just passed out that was with the help of OPLC, which would make it so that the subcommittees need to have approval of the executive director of OPLC in order to create those subcommittees. That allows some control over the process of subcommittees so they don't metastasize and just spread over the whole body of these boards, while also making sure that they will be nimble enough to do the job that we ask them to do. And so that amendment that I've handed out, 0390H, would allow the subcommittee section to have a little bit more structure, but not require us to change the statutes anytime that somebody wanted to have a subcommittee for a board. Additionally, in the second section, we have already repealed one of the laws around the ophthalmologic dispensing. And so now removing the references to RSA 327:6A, 6 now makes it so that our law no longer has what I like to call a bad link. It's no longer linking to repealed statutes. And so that's what happens throughout Section 2 of this bill. And additionally, there were two sections that were found that needed to be, actually, this does have that repeal as well, but that's because that's something that's no longer really functioning. That was already dealt with previous legislation, but there were still some sections left behind, and that is what the repeal section is for. So this is a legislative cleanup coming out of GELCAR, and this is something that if we need to have a subcommittee on it and look at some of these administrative rules, we can include that in the process. If this is more straightforward and others are happy to move forward with it, that would work for me as well, and I'm happy to answer any questions.
All right, any questions? Representative Sitek.
Representative Leon, what hat were you wearing when you brought this?
I was wearing the hat as the vice chairman of the joint of GELCAR.
Your vice chair. Okay, thank you.
Yes.
Any further questions? Representative Dargent.
Yeah, I've not seen the amendment that you referenced.
Oh, sorry. I think it's in a stack right there to send to that side of the committee. My apologies.
Representative Sitek.
The boards need legislative approval to set up subcommittees?
Yes.
Wow. Okay, thank you.
And that's what this bill would do, just generally allowing the subcommittees the way that it's written, but the amendment provides a couple checks and balances just to make sure that it's still well focused, but doesn't require this entire process.
All right, seeing no further questions, thank you for your testimony, and I don't have any other
Thank
pink
you.
cards. Dee, do you have a card? Would you like to speak?
Stack of OPLC cards
Uh,
I just lost.
Dee, please, if you would.
Good morning. Just for the record, Deanna Juris, Executive Director, OPLC. Thank you for allowing me just a minute to speak. On the proposed language of the amendment that you have in front of you, I just wanted to speak. The way that statutory construction exists, right? It looks like I am just power grabbing all over the place, and like I want to control all of these things personally. And I wanted to just make clear. So the request for language that clarifies this in statute is because much like this committee, this large group, sometimes you say, hey, we're going to notice a subcommittee or a work session and 5 of us are going to get together and work on this bill. We do it in public. It's noticed that you're all members of the board. So there, Department of Justice has said the licensing boards have that same ability. You can notice a smaller subset, a smaller group of that larger body to do some work, you know, in accordance with 91A, notice it publicly, do the work. You can have public comment. All of that piece is there, all set. The challenge is that we, as previously discussed, right, we have limited number of staff. So if every single board said, I want 5 subcommittees or even 1 subcommittee, it would double the amount of board support that the office is providing. And so we need to just make sure that we have some ability to say, yes, you can meet this often or in this place. And so that's that is the kind of the request, to have that clearly put there, is to say we want to make sure it's for a specific need, to determine the duration potentially, or the topic there, so that we can provide appropriate support to them doing that. So the other piece of it is sometimes we wanted to really clearly define subcommittee, because sometimes there are subcommittees that are authorized, that are part of the board, and then have members on them that are not on the full governing board, the full licensing board. And what was happening is there was some sprawl there where boards were establishing committees, but then non-appointed members were conducting board business. And so there was concern about that and potentially the ramifications of that. So we just wanted to make it really clear, this is what the process looks like, lay it out clearly. So that was the request, is just to provide that clarity. But to provide the flexibility, I'll give one example. The Board of Electricians has their code updates every 3 years, and so they have to update their exam on the code, and it's a huge lift, right? If you've ever seen that manual, it's massive. It's very technical, and so they have specific statutory authorization to have a subcommittee for that purpose, and so we just want to make sure that they can be flexible, that it doesn't require the full board to be there for all of that. So it's things of that nature that we're trying to allow that work to happen.
Very well. Representative Groda.
Thank you. I just want to make sure that the amendment as written gives you the flexibility that you need for these subcommittees.
I don't have the language in front of me, but if it is as I presented, it is as Attorney Fry drafted for me before his departure from the office. So I can double check it for you before you vote, or yes. So I'm happy to take a look and confirm that for you, but thank you.
Do you have a question, Representative Sitek?
Departure from the office?
Attorney Fry took a promotion of the Department of Safety. Thursday was his last day.
Okay.
You could wish him well. I'm sure you will see him around, but yes. So you're stuck with just me for the rest of the session here. Lucky you.
Wonderful. Are there any other questions? Thank you so much. Okay. Seeing no further pink cards, I will close the hearing on House Bill 1312. Thank you. I'll try to. Let me know when you're ready, John.
Okay, the clerk has informed me that he is ready, so we will open the hearing on House Bill 1261, and I call Representative Leon to present her bill.
Thank you, Chairman Pearson. For the record, my name is Erica Leon. I represent the town of Derry, Rockingham 13, and I'm here to introduce House Bill 1261, which is a large and significant look at the entire Administrative Procedure Act that has been drafted by the Director of the Office of Legislative Services in charge of administrative rules in order to ensure that the statutes that we have are consistent with a clear and standard way of moving forward. Most of them are just standard technical corrections within this, and this is something that we probably will want to take a look at in subcommittee. However, it is an important bill and one that is also moving forward in the Senate. I do have a small amendment that I will also hand over that came from Director Osterhoff to take a look at this. So as we look through actually, I think I'll just defer for the technical introduction because this is complex, and I believe that Director Osterhoff can probably walk us through it pretty well, and then we can all work together on this as well in a future work session. So are there any questions?
Sounds great. Thank you, Representative Leon.
Thank you. And I will pass the amendment just so that you have it, although I don't know that we're getting into those technical things.
Thank you.
Good morning, Douglas Osterhout, Director of the Division of Administrative Rules for the Office of Legislative Services. So this bill was actually at my request. This comes from having worked on both sides of this bill, both in the executive branch and as Director of Admin Rules. And really, the majority of this bill is just rewriting for clarity. There aren't a lot of substantive changes in it. I did submit some written testimony that highlights some of the key points. One of the things I did was 541A13 is in my written testimony because my note when I was going through my redraft of the APA was complete overhaul. I didn't change anything substantively, but I completely redlined it to the extent when it got to OLS, they did a repeal and replace, but I thought you might like to see the language that was originally there. It just, for your convenience, it's all in one place. That's why I did that. So the majority of it is just clarifying the language, not really making a lot of changes. There are a few changes, mostly just to accurately reflect what's already happening, right? So like the committee doesn't necessarily send things to agencies. OLS staff does that on their behalf, those types of things. One thing that changes, and this was at the director of the Office of Legislative Services, James Vara, before he moved on, request, they're going to shift some of that responsibility from the director of OLS to the director of admin rules because we're the ones doing the work. We're the ones making the recommendation. We're just basically removing a layer of bureaucracy. There's another change in there, a couple of changes. One is right now, an agency, if they want to do a quick revision to a form, they're not allowed to do that. We have expedited procedures for other things. What this does is kind of strikes the balance. There's always a concern about fiscal impact and fiscal impact statements. This, we've created a new process that's going to speed that up. So rather than taking 3 to 6 months to get a form updated, we'll be able to do it in 1 to 2. It still requires a fiscal impact statement, and it's pretty limited in use, but it's just one of those little quality of life sort of boosts for the agencies. The amendment that Representative Leon referred to is for interim rules specifically. So there's certain conditions where an agency can do interim rules. One of them being to conform the rules with new statutes or amended statutes, but they have a really limited window to adopt and make those rules effective. So what I'm trying to do, we've seen situations where, say a statute has an effective date of January 1. If they go to GELCAR in November, they're going to fall outside of this 30-day effective date window. So they need a waiver in order to postpone that. Or if they come to GELCAR in December and a rule gets postponed and it doesn't get seen by the committee until January, there's essentially 3 or 4 weeks there without admin rules where we don't have to have that gap. So all I'm trying to do is change it for this very specific instance. If an agency is doing an interim rule to comport with a statute, they can do it within that time frame or the effective date of the statute so that they don't have basically a 1 meeting window to meet. It'll give them a little bit of leeway and flexibility. Other than that, like I said, it's a lot of cleanup language. It's just for clarity. And I'm happy to answer any questions.
Representative Schmidt.
Thank you, Mr. Chairman. So, other than that, on the interim rules, it stays as it has been for donkey's years?
Correct.
Thank you.
Representative Grota.
So just for clarification, this would apply to all agencies that are going to present rules to JELCAR.
Correct.
Correct. Okay, thank you.
Excuse me, unless there's an exception, but yes.
Yes, excuse me, that's right.
I don't want to get too technical, but yes.
I have one for you, just in the sense that you referenced 13. So, because most of this, which is on for everybody's help, it's page 13 in the center, section 17, it's line 18. Because the rest of this is written as typical redaction and addition, right? In the way we strike out language and boldface language. Except in this particular section, just for clarification, you said that OLS decided to make life easier for themselves and just, which is what they did, and just so that people understand if they're reading through this, why all of a sudden the normal format stops. Just clarification that's, because I thought that's what you said.
That is, I think we're saying the same thing.
I'm just asking for
Yeah, so
clarification.
I did sort of like you said, the explanation, bold italics, all that. And then as you can see from the written testimony, hopefully you have in front of you, when I got there, the rewrites were extensive, but they're not changing anything. So if you were to look at 13, paragraph 5A, for example, that is a block of text that is half a page long. All I did was put in an introductory sentence and then list out the requirements 1, 2, 3, 4, 5, 6, so it's easier to read. None of the requirements actually changed. And but rather than put in this, I don't know if you can see it, but this is my version where I just literally crossed out all of the existing language and then redrafted it below. They thought that unnecessary, and just it's a cleaner way.
Right.
But I think for the committee, if you're trying to compare the language, it helps to have both. And so I just provided you with with that.
Perfect.
Are we going to need maybe a side-by-side from our administrative assistant to see that, or is it really easy to?
It should be really easy. So every change that I made is done where the old language is still there, except for in that one section, which is why I provided my draft in my written testimony. So you should have everything you need in front of you.
Right, it makes perfect sense. Okay, thank you.
Perfect. Any other questions from the committee in reference to 1261? Perfect. Seeing none? Do we have any other cards for this one? We don't. Seeing that we have no other pin cards, is anybody here that needs to or desires to testify on 1261? Seeing none, we'll close the hearing on House Bill 1261. You know, once or twice I've done this. That should put us at lunch. That's my favorite bill.
Thank you all. That concludes our morning's business. We knew essentially the amount of time we needed to do, but even though the first one ran over, we were able to work within our time frame. I will see you again at 1 o'clock.
I know.
Take a breath. You want my microphone still? It being just after 1 o'clock, we are back at the House Executive Departments and Administration Committee, and I will open the hearing for House Bill 1506, creating an exception to the restricted uses of artificial intelligence by state agencies, and welcome up the prime sponsor, Representative Thomas Corman.
Thank you, Madam Chair. I am Representative Tom Corman. I represent Grafton 15, which is Ward 3 of the City of Lebanon. I appeared before this committee last year for a bill about the flag, and also 2 years ago about something very related to this bill. Just a little background. I'm an emeritus professor of computer science from Dartmouth College, where I was on the faculty for 29 and a half years. I chaired the department for 6 years, from 2019 to 2015. And I've actually been in computer science since 1974. So I'm actually in my 52nd year of doing some form of computer science. I'm actually best known as the lead author of a book called Introduction to Algorithms, and I hope it never falls on you. It's very big and heavy. But this bill is about artificial intelligence, and I just want to be clear that my own research was not in AI. It was more in algorithms and systems. However, I've kept up with developments in AI over the years, in large part because as chair of my department, I needed to keep up. But I've really been tracking AI since I started grad school back in 1984. So really like 42 years of tracking what's gone on with AI. So I was here 2 years ago because I wrote and co-sponsored HB 1688. And this was a bill on AI. It had bipartisan co-sponsorship. And this committee made some very constructive amendments to it, so I really appreciated that. And it's been enacted as RSA 5D. I thought it was kind of cool, like my first bill actually gets a really low RSA number. So what does that bill do? And the reason I'm talking about that bill is because the bill before you today actually amends this bill. So RSA 5D puts common sense guardrails around the use of AI by the state of New Hampshire. The bill defines AI and deepfakes, and just parenthetically, we used those same definitions. We made sure to coordinate those same definitions in 2 other bills that went to 2 other committees. HB 1432, which prohibits damaging deepfakes. So if, say, I made a deepfake of you robbing a bank and you got arrested, I've committed a felony and you can sue me. And then also HB 1596, which went to election law, and that prohibits deceptive deepfakes in elections. And that was very timely because that was during the primary when we had the fake robocalls from Biden. So we made sure to coordinate definitions so that we had consistent definitions of AI and deepfakes in all those bills. That's parenthetical. So back to what HB 1688 does. It prohibits state agencies from using AI in bad ways, classifying people resulting in unlawful discrimination. It prohibits real-time and remote biometric identifications for public surveillance without a warrant, and also prohibits the state from using deceptive or malicious deepfakes. The bill also says, and this is probably the most important part relative to the bill that we're going to be discussing, if AI makes a decision or a recommendation that once executed cannot be undone, then you have to have the appropriate human in the loop. And the example that you might recall me giving was that, let's say there's a hostage situation, the state police send in a robot, the robot does not decide whether to shoot, right? Because you can't unshoot someone. The bill also says that AI generated material that is not reviewed by a human must be disclosed as AI generated. And that if a human is interacting with AI through the state, they must be told that they are interacting with AI through the state. So if you're on a state website and you're having a conversation with an AI, you have to be told that you're having a conversation with an AI. And the bill does have some simple exceptions, the bill that was passed. It accepts systems used in research by state-funded institutions of higher learning. So if someone at UNH is doing AI research, they're not subject to this. And also installed consumer systems in personal systems in common use. So, AI for facial recognition so you can unlock your smartphone. That's not covered. And the bill also requires state agencies to review their use of AI to make sure that it conforms to the RSA. All right, so that's the history. And that's where we are right now. I'm here because in December of 2024, I was having a conversation with a fellow, that's with a capital F, at the Mercatus Center at George Mason University. It wasn't just a guy, it was a fellow, about AI and RSA 5D. And we were talking about how AI can be used to thwart denial of service attacks on computer systems. And for those who maybe don't know what that means is, imagine that you're trying to really shut down a computer system. You keep sending it requests. So let's say I want to take down a website. I keep just flood it with requests and it just can't keep up. That's called denial of service. So we were talking about maybe you can use AI to thwart that. But it occurred to us, well, you're not going to have a human in the loop in that situation. And these are decisions that can't be undone. So there's a problem here because the bill or the law would prohibit using AI to try to protect the computer systems. So this is a case where AI is making decisions without the appropriate human in the loop, could be. So I contacted Commissioner Goulet from the Department of IT to discuss this. And he pointed out, well, maybe what we really need is a more general exception mechanism for RSA 5D, not just about denial of service, but just some way that a state agency can request an exception to RSA 5D. So that's what came out of that conversation, and I worked out with Commissioner Goulet the bill. So the bill creates a procedure for state agencies to request an exception to RSA 5D. And the two key things about it are, first of all, it has 2 checkpoints. And the second thing, it's designed so that it could happen quickly. So the 2 checkpoints are, first of all, a state agency commissioner or head says, okay, I need this exception to RSA 5D. They contact the commissioner of IT and explain what they want and why they want it. And if the commissioner says, okay, that makes sense, then it goes to the second checkpoint, which is the executive council. And the executive council would have to approve it. The commissioner of IT has 30 days to either approve or deny, so that can happen fairly quickly. And then we have the executive council, and the executive council meets frequently. So it's not something, the way the bill is constituted, it's not something that can happen immediately, but it can happen relatively quickly, at least compared with, shall we say, the speed of government. So that's what we have. At first, I was considering having the second step be JELCAR instead of the executive council. And in fact, the first draft of the bill had JELCAR, but as I thought about it more, I thought, I think the executive council is a little better because this isn't really about rules. This is about how the agencies operate. And this is the place where you guys look at that and the executive council looks at that. And also, I think the executive council meets a bit more regularly than JELCAR. So I just felt like that probably makes the most sense. So that's what the bill in front of you has. It just creates this 2-step exception mechanism that can happen by government standards quickly. And with that, I'm very happy to take questions.
Thank you very much. Representative Long?
Are there other examples in current statute of where the executive council is responsible for approving an exemption to the statute that you know of?
I do not know of any such examples. I know that the bill, section 4 of the bill, of this bill, actually amends RSA 4, which is about the executive council. I have to confess I haven't read all of RSA 4 to see if it has anything else about exceptions.
Thank you. Sorry, Representative Thiebaud and then Representative Dargy.
Thank you, Representative, for taking my question. You mentioned DDoS attacks in your testimony, and if someone wants to have a targeted DDoS attack against the state, that can happen very quickly, quicker than the commissioners and the executive counselors could approve that. So could you speak to how that approach would work to actually stopping DDoS attacks, and perhaps explain how AI can be used particularly to stop those attacks?
Thank you. So again, I'm not an expert on AI. So this just came up in the conversation I had with the fellow at the Mercatus Center that AI possibly could. And you can imagine AI is running in the background and seeing this pattern and saying, yeah, this looks like a denial of service attack. Beyond that, I'm not going to give you any details because AI is not really my area. If you want to know about shortest path from point A to point B, let's talk. And then the other point you raised is actually a really good point, and I've thought about it a bit. And of course, it's the committee's bill, and the committee may choose to amend it. And one of the things I thought about is perhaps maybe one way to do this would be to say that the commissioner may immediately have the exception, but then it has to get reviewed. So that might be one way to amend the bill to allow for, a very quick turnaround, but still make sure that a decision that violates 5D isn't there forever. But that's the committee's bill. But that was something I did think about after I filed the bill. So thanks for the question. It's a great question.
Thank you, Representative Dargy, and then Representative Schmidt.
Thank you, Madam Chair. Do you have any rough guess as to how frequently this will be needed? How many requests for an exception will occur per year?
When Commissioner Goulet and I conversed about it, we conversed over email. I got the impression from him that it would not be frequent. I don't think that we're going to see it in every executive council agenda.
Thank you. Representative Schmidt?
Thank you, Madam Chair. So, as you probably know, the state is being attacked every day, hundreds or maybe thousands of times. I've talked with some of our staffers and so forth, and that's been the case for years probably. So what's the difference between that kind of hacking and the denial of service situation that you're talking about in terms of frequency?
Yeah, so I mean, the ways that people would attack the state might be to try to get in and just get into some account, so to create mischief rather than shutting things down. And the idea here is that you might use AI for all sorts of things, and you might want to use AI for all sorts of things that have nothing to do with protecting computer systems. And I just want to make sure that if there's a legitimate case for going beyond the guardrails of 5D, that we have a mechanism for allowing it legitimately.
Follow up.
Thank you. So the thing is that we know Commissioner Goulet from, most of us do anyway, from his regular appearances before this committee. So is he an expert in AI? Because you've candidly admitted that you're not an expert in AI. Have you talked with somebody who is with regard to your idea, if Goulet is not in that category?
I have not, because I felt that this isn't really about the technical aspects of AI. This is about the administrative aspects of using AI.
Thank you. My question for you is if you would be amenable if we amended the bill so that when the Commissioner of IT sends us to Executive Council, he also notifies, he or she, depending on who's in that role, notifies some people within the legislature, just so that there can be a few more eyes on it before it's published 24 hours before the Executive Council meeting.
Well, of course, the real answer is it's your bill now. So whether or not I like what you've just said is not relevant, but I do like what you just said.
Thank you. And then my last question, oh, sorry, I'll let Representative Pearson ask his question.
Oh, I wasn't trying to cut you off here. You mentioned so the deep fake thing, right? That is very concerning to me in a lot of ways, right? Because of the way that it's the potential of that to put me on the Apollo 14 rocket, to put me in Tiananmen Square, to put me in a place I never was, doing things I wouldn't do, right? So how do we, and I know you're not an expert in this, but it's a generalized question. Do we have the ability, when one of these things occurs, is there analysis that can happen to immediately go, that's not real? Does that exist?
There are techniques. Actually, one of my former colleagues at Dartmouth is probably the world's expert in determining whether something's a deep fake. But, it's a cat and mouse game, right? So as the technology to detect deep fakes improves, so does the technology to create them. That, of course, isn't really part of the bill. The bill just prohibits deep fakes by the state. Or actually, HB 1688 does.
Well, follow up to that.
Follow up.
If they're prohibited, though, we have to have a way of knowing that you have done something that is prohibited, right? So there has to be a way to identify this sort of thing to show that you have violated whatever. So that's where I'm going with that.
Right. And yeah, I mean, there are techniques, and I mean, a lot of deepfakes are very poorly done, but they are getting better and better. But so are the techniques to detect them.
Thank you. Representative Long?
As related to that, I guess I have some concerns about the broadness of this bill. So is there ever going to be a situation where the state has a legitimate use for creating deceptive or malicious deepfakes?
I can certainly imagine a situation where the state would create a deceptive one that wasn't malicious, right? So, I think one of the examples I was thinking was, imagine a deep fake of Abraham Lincoln telling you not to start fires or something like that. As far as malicious, I can't imagine a situation where the state should be creating a malicious deep fake. Yeah, I mean, maybe, no, I can't think of one.
Thank you. So my next question for you is, within the statute that was already established previously, 5D, are agencies able to do things like use AI to review how administrative rules and laws line up, or how licensing lines up with that? Is that something that's currently permitted and wouldn't need an exemption like this?
As long as there was no discrimination involved, it should be fine.
Thank you. And then my second question, with you being at Dartmouth and the late great C. Everett Koop also being there, and not liking the term expert because it sort of puts a cap on your knowledge, to me it seems like you have the level of knowledge a lot of people would call themselves an expert. Is this just simply you being very cautious about not overstating your credentials, because you seem to know a lot on this area?
I am really not an expert on AI. I mean, I really try to be upfront about that. I never did research in AI when I was in grad school, and there was an AI course. I actually just audited it because I just needed to pass the written exam for the quals. So I didn't do any of the assignments. I ended up doing really well on the qual, but I'm not an expert. And like I say, I've been tracking it. Right. And, so if you want to ask me what was AI like in 1985, I can tell you what AI was like in 1985. If you ask me how did they do it, I can't tell you exactly how they did it. And if you ask me now, how does a deep neural network, I could probably tell you enough to confuse you, but not enough that I might be accurate.
Thank you. Are there other questions? Representative Schmidt?
Thank you, Madam Chair. So I'm online quite a bit, and I noticed on YouTube, for example, that the narration is very good in terms of the language, very nice voices and so forth. But you can tell almost immediately when it's an AI, because they do things that I would venture to say very few, if any, human beings would do. And the thing is that as smart as the program is, it's not smart enough to know where the end of the sentence is sometimes, and it'll stop after the word street where there's a period, when no human being, well, maybe a new reader who's 4 or 5 would do that, but you can tell immediately that it's AI. And since we have a few minutes, I thought I would plumb the knowledge that you do have by asking you, why is it that the program cannot figure out how to read a sentence? They go along and they're doing beautifully, and you think it's a human being until they do something when you know it's immediately it's not a human being. Why can't a program yet, if you know?
Yeah, I mean, I can't tell you technically why that is. What I can tell you is that, I think we all know that AI is getting more and more capable all the time. And, any particular complaint that you have today probably won't be a complaint you have in the future. What's amazing to me is some of the things that AI has figured out, just since you opened the door here. In computer science, one of the things that we often have to do is multiply 2 matrices. And the number of scalar multiplications you need to multiply 2 matrices can have a big impact on how to multiply big matrices. And several years ago, many years ago, there was an algorithm that came out, and normally you'd have 8 multiplications, 8 scalar multiplications to multiply 2 matrices. Somebody figured out how to do it with 7, and that was huge. Well, AI figured out how to multiply 2 7 by 7 matrices with, instead of 49 multiplications, 48 multiplications. Nobody had ever figured that out before, but AI figured out how to do that. So we're seeing AI getting just more and more capable and actually coming up with things that people have yet to do.
Thank you. Are there any other questions? Representative Thiebaud?
Thank you, Madam Chair, and thank you, Representative, for taking my question. So in Section 5D3 of the statute, there is a list of 3 prohibitions that there are no restrictions. It's just you cannot do them. And as Representative Long said earlier, in that is a deceptive or malicious deepfake. But there's also real-time and remote biometric identification, with the exception of with a warrant. Do you see any situation where a commissioner would need to be able to remotely surveil people without a warrant? And do you think that there should be restrictions on the exemptions from restrictions that exist within your bill?
Thank you for the question. Actually, the bill, as I introduced it 2 years ago, didn't say except by law enforcement with a warrant. It actually said except to find missing or abducted persons. That was the use case I thought of. And the committee decided to make it more general. Would there be other situations? I don't know. And that would be a case where where a commissioner would request an exception.
Thank you. So when you're looking at these exemptions, are you looking to look at exemptions to the permitted uses and restrictions, or in 5D4, or are you looking to do this against the strict prohibitions? Because I think that a bill that would allow exemptions and exceptions to the restrictions on use would be probably a smaller lift than to also making exemptions to the straight prohibitions that are in 5D3.
Yeah, I mean, my thought was that there might be a use case for exceptions to the prohibitions, not just the restricted uses, right? And maybe for some reason forced surveillance without a warrant. I don't know what it would be, but the point is that by having these 2 stages of checking, a commissioner couldn't just go and make the decision unilaterally. It would have to be approved by the Commissioner of IT and by the council.
Thank you. Are there other questions from the committee? Seeing none, thank you very much. Is
Thank
there
you.
anybody else here to speak on House Bill 1506? Seeing none, I will close the hearing. And we'll be back at 1:30. It being 1:30, I will open the hearing on House Bill 1683 relative to the modification of administrative rules by the Joint Legislative Committee on Administrative Rules. And I will call up Representative Kelly Potenza.
Thank you, Madam Chair. Just for the record, Representative Kelly Potenza, Stratford District 19. So thank you, of course, Chairwoman, Vice Chair, and members of the committee. Thank you for the opportunity to testify in strong support of HB 1683. Of course, I would support it. It's I'm the prime sponsor. But I believe that this bill is desperately needed in New Hampshire because it addresses one of the most serious constitutional failures of our time. The legislature's longstanding abdication of its lawmaking authority to unelected bureaucrats and executive branch appointees. So, the New Hampshire Constitution vests lawmaking power in this body and nowhere else. The New Hampshire Constitution is explicit. Part 1, Article 1 states that all government of right originates from the people. Part 2, Article 2 vests the supreme legislative power exclusively in the Senate and the House of Representatives. Agencies are not lawmakers. They are not constitutional actors. They exist only because the legislature created them and only within the bounds of the legislature sets. This is not a technical distinction. It is the foundation of representative government. So the Constitution is a trust agreement, and we are the trustees. The Constitution functions as a trust grantors, the people of New Hampshire, the trust instrument, which is the Constitution. The trustees are the elected legislature, and the beneficiaries are the people themselves. Under Part 1, Article 10, the people reserve the right to perform government when it fails its duty. That article is not symbolic. It's actually a warning. So for decades, the legislature has failed to defend this trust. We have ceded, yielded, and in many cases effectively transferred our authority and the people's rights to unelected and appointed officials who were never granted lawmaking power. HB 1683 is not radical. It's not corrective. It is the legislature finally acting as a faithful trustee. So the non-delegation doctrine is a constitutional requirement. So it's not academic theory. It flows directly from the separation of powers mandated by Part 1, Article 37, which requires that the legislature, the executive, and the judicial branches remain separate and independent. When agencies write rules that create new obligations, impose penalties, restrict liberty or property, or establish statewide policy choices without clear statutory authorization, they are exercising legislative power they do not possess. HB 1683 enforces what the Constitution already requires. Agencies may execute the law, but they may not create the law. The rulemaking process has been reversed, and that must stop. For far too long, the cart has been driving the horse. Instead of statutes guiding rules, rules now drive statutory interpretation. Agencies routinely promulgate regulations first and search for authority later, if at all. Or to put it another way, the bus that's owned by 1.4 million people hired a driver and gave clear directions for where the bus was to go. Instead, the driver stepped away. He took a vacation, and he handed the wheel to a friend who has always wanted to be the driver. That friend is now taking the bus down roads never authorized by the owners, far from the route they approved. HB 1683 restores the proper order. Laws come first. Rules must follow. If a rule cannot be clearly traced to a current RSA, it does not belong in force over the people. So this is really about protecting the people's rights, not attacking agencies. This is not an anti-agency bill. It's a pro-Constitution bill. Administrative rules touch nearly every fundamental area of life: property rights, occupational freedom, medical decision-making, parental rights, small businesses, municipal governments. These rights are protected by Part 1, Articles 2, 3, and 12, and 15. Such rights may be limited only by law enacted by the people's representatives, not by administrative interpretation. Every rule that lacks statutory authority is a quiet injury to a citizen who never voted for the person imposing it. HB 1683 restores democratic accountability. So, federal compliance and expertise do not override the Constitution. Agencies may argue that federal mandates, expertise, or public safety require broad discretion. But federal funding conditions do not amend the New Hampshire Constitution. Expertise does not confer sovereignty. Convenience is not constitutional authority. If federal compliance requires new obligations on New Hampshire citizens, the legislature must enact them. If agencies believe statutory authority is insufficient, the remedy is to return to the general court, not to legislate by rule. Emergency powers are not a justification for permanent rulemaking. True emergencies already have statutory mechanisms. So, what HB 1683 stops is the use of permanent administrative rules, or even temporary ones, justified by hypothetical or indefinite emergencies and/or we know better mantra. Public health, environmental protection, transportation, and safety policy are among the most consequential legislative decisions a government can make, and they belong here. The fiscal note is not necessary. Constitutionality is not optional. I do not believe the fiscal note is necessary or even persuasive. Nothing in the Constitution requires the legislature to fund unconstitutional governance. Oversight of administrative rules is a core legislative function, not a new program. GELCAR already exists for this purpose. Legislative Services already performs complex constitutional and statutory review across policy areas. This work can be assigned, phased, and prioritized without expanding government or hiring additional attorneys. The true cost is not enforcing constitutional limits, and the true cost is failing to enforce them. So I'm willing to work with this committee. I think you have the second best committee in the House because E&A, Environment and Agriculture, is the number one. A wonderful bipartisan committee that you guys have. You do great work. You have incredible subcommittee work that has been the case for as long as I've been in the House. So I'm feeling willing to work with the committee on amendments. I know that this is now yours. There may need to be some, of course, there always has to be tweaks, clarifying scope, maybe refining and redefining, the auditing piece that was in there, phasing in implementation. But the whole point of this is to ensure that all future rules are firmly grounded in statute. The shared objective is simple and constitutionally required. From this point forward, rules must be based upon law, not habit, not convenience, or agency preference. The people did not elect agencies. They elected us. For far too long, we have failed our duty as trustees of the Constitution. We have allowed convenience to replace duty and delegation to replace accountability. So I believe that this is the first meaningful step toward correcting years of unconstitutional drift and restoring lawful government in New Hampshire. And I respectfully urge the committee to recommend not to pass on HB 1683. Thanks.
Thank you. My first question is, you gave us a list of new obligations, creating penalties, and I was not fast enough to get that entire list of your specific concerns where we're granting authority outside of our, where rules are being done outside of statutory authority. Could you get me what that is when you said the new obligations create penalties? I think you were probably in your first page, about halfway down would be my guess. Or if you could provide a copy of a written testimony.
Yes, I'm going to totally give you this. I wanted to have it first here. I'm just using that in a general sense during my testimony, because if we just look at specific rules that create obligations and sometimes, of course, fines and penalties. I was just saying that in a broad sense. I did a deep dive on, of course, DHHS and DES and DOT, and there's just so many at this point. But this whole bill really came about because of what took place last year with, or was it oh gosh, it might have been in 24 at this point, in regards with what happened with some rules that took place with DES and landfill siting rules that needed to be renewed. And so every single thing that was done the right way, the legislative way, was ignored, subjugated, or whatnot. And so that's why I'm here. Because they basically just went off of their own. They ignored all expert testimony. They ignored every single bit of where we could take pieces of legislation. And then the piece of legislation that was the guardrails passed, of course, the House and then was killed in the Senate. So that's why I'm here. So.
Thank you. Are there other questions from the committee? Thank you. I know this is something you've been working on, and I thank you for working to try and bring something constructive forward.
Yeah, and I really do believe that we can make something happen. I understand that, you know, I know where everybody comes from with this, and, you know, we all get paid such a large amount of money. But I really believe that small steps coming back to how it was all supposed to be designed, foundational, constitutional way, and those separate powers that we have is going to bring us and bring the people back into order. So.
Thank you. Oh, sorry. Representative Schmidt has a question. My apologies.
Thank you, Madam Chair. So can you give us a specific example of some place where some agency has promulgated a rule because I like the idea that we wouldn't want the agencies running the world. The legislature and the government should be ahead of that, specifically the legislature, Article 1. So can you give us a specific example?
Yeah, I could give you.
You cited something that sounded like an example, but I wasn't sure what case it was because I recall something that didn't sit very well with the ED&A committee in those days, but I'm not sure if that's what you're talking about.
There's several, and I don't want to go down the path of in regards that has to do with my committee with Environment and Agriculture and DES, because that's a really long answer, and there's many different pieces of that. Let's just use a simple one. So this is DHHS, and I believe it was 2022, so this is before I was a rep. A simple change was made to our religious exemption for immunizations for the schedule for children. The change that was made in statute was, and this was the mistake, but I don't even realize how it should have been a mistake, but it was. It went from parents having to put a statement forward to a school or a daycare in regards with their religious exemption, and then there was a notary. We removed the notary. The body did, because that was unnecessary. Someone shouldn't have to get their religious beliefs notarized. So that was a good thing. But then what happened is that statement changed to form. DHHS took that upon themselves to build their own form on their website, put a shall in there, and told everybody that you have to fill out that form now for your religious exemptions, which for decades, people wrote their own statements, and it just didn't make sense. I immediately developed my own form that had no, of course, notary signature on it. It was the form that I had, pretty much used before. But the problem with that form right now that is on DHHS's website, I believe it's unconstitutional. It breaks people's privacy. It's intimidating. It actually has a piece where you would have to continue to fill it out every year. That's not the case. If your child, once they're in the school system, they wouldn't have to. So they took it upon themselves for, people's, private rights of having a religious exemption and made a form and did all of that. And now we have to try to undo that. Now, I assume that in this bill, you guys have it now. There could be a place where we make it easier to say, okay, here's a rule that's in place and petition that or something to say that that's not what the intention was. Because if you look right now in the current law, it says that you just have to fill out a form. It doesn't say there that you have to go fill out the government form for your religious exemption. So that's just one example of many, which is trampling on people's private rights. So, but I think there's a lot of different ways that you can skin this cat, and to be able to bring it back to some sort of normalcy and get some of these things that are in place now back in order.
Thank you. Are there other questions from the committee? Seeing none, thank you. Next, I'll call Doug Osterhout from OLS Division of Administrative Rules. And on this, we only also have OPLC that'll be speaking on this issue, right? Is anybody else here to speak on it? With that, you're just going to support that. I'm going to relax the time frame just a little bit because otherwise we'll be setting off timers and then recessing.
Good afternoon. I do intend to be brief. Obviously, if there's questions, I can stick around. Douglas Osterhout, I am the Director of the Division of Administrative Rules for the Office of Legislative Services. Thank you for having me here this afternoon. So I did send out some written testimony. I don't know if everybody had a chance to review that yet, but I think one of the things that stands out immediately in my eye is, well, first of all, I want to address the constitutionality comment. I did not come here prepared to defend the constitutionality of administrative rules in the state. One thing I will share with the committee, I will send this out when I get back to the office. In 1981, there was an opinion of the justices from the New Hampshire Supreme Court that does a pretty deep dive into the constitutionality of administrative rules. Essentially, the executive branch has no inherent legislative authority, but the decision was the legislature could delegate with parameters that authority to the executive branch. And a big reason they could do that is the JLCAR process and the system we have in place today. So there is some legislative review and oversight of administrative rules. Like I said, I will share that opinion of the justices when I get back to the office. I'll just send it out to the committee. So a few things I wanted to point out, and this is in my written testimony, is I think a lot of the things that this bill is attempting to accomplish can already be done with existing law. So we've pointed out that when a rule is proposed, an administrative rule is proposed in this state, it undergoes substantial legal review. At the notice stage, we check for rulemaking authority. We get an appendix. Every single rule in the state has an appendix that identifies the statutes being implemented by that rule. And we review rulemaking authority and sometimes to a lesser extent, the statutes at the rulemaking notice form. We do that when the initial proposal is sent to the office. Every single rule undergoes 2 legal reviews. And one of the things we're doing in that review is checking all the legislative authority. And then at the final proposal stage, we're doing a review of that rule again. So it is safe to say that every single rule that comes through our office gets 4 legal reviews for statutory authority. Now, we may disagree sometimes, right? The 5-inch diameter being a recent case. But that doesn't mean it hasn't undergone legal review. And then if we are very quick to call out and we talk to the agencies, if somebody doesn't have statutory authority, we flag that because that is a red button topic for us. So I wanted to point that out. It undergoes, I'm not looking at the right document. So that extensive legal review, I quickly put a bullet list together of sort of the things that we do. All of the rules expire after 10 years, so there are very few permanent rules. We do have procedural and administrative rules, typically in the 1 and 200 sections of an agency's rules. Those don't expire, but if the law changes, agencies are required under the Administrative Procedure Act to modify those rules. If an agency loses this statutory authority, the rule becomes invalid. I'm not sure that's entirely clear. That has always been in the interpretation, but the bill we saw this morning has that language explicitly in there. So when we did our redraft of the APA, just for clarification purposes, again, that's always been our interpretation, it will explicitly say that. So if an agency loses statutory authority, the rule is invalid. I mean, we are talking about the entire GELCAR process, really. The whole process exists to make sure that agencies don't enact administrative rules outside their authority. And then some of the remedies too I'd like to address. You can already modify the law. If you think an agency needs to be curtailed, the legislative branch can do that. If you think an agency is acting without its scope or improperly, you can already notify the governor. You can already notify DOJ. I don't think you need to explicitly put that in this bill. The other thing, there was comment about OLS being able to absorb this. So as the director of admin rules, I have a very, very small staff. It's myself, 3 staff attorneys, and then 2 administrators. We could not conduct a review, which, as I said, is a bit redundant because we're already checking for authority every time a rule is proposed. We could not do a review of every single rule in this state every 2 years with the staff we have at hand. When I proposed, I would probably need 3 additional attorneys and an administrator. I said that was probably being generous, and once, if I was doing this project, I would have to reevaluate. It could require more staff. It could require less. I don't know. But my estimate off the ground would be probably 3 attorneys, 1 more administrative position, and then office space. So I think $500,000 was a relatively conservative estimate. And then the other thing is, again, approaching those remedies. Some of those already exist. The agencies already have those at their disposal. But the other one, where an agency would have to repeal or amend a rule within 90 days or less, that is, practically speaking, not really possible. If an agency is going to amend a rule, the process right now takes about 16 months. And I think the executive director of OPLC is here, and she'll probably speak to this. She may speak to this. But I think she said on average it takes a board around 13 months to promulgate a rule. So the 90-day window is a bit realistic. If we do proceed forward with this bill, I think we need to tweak, and we'll probably have to develop a new process to meet that criteria. And then also, like I said this morning, under 541A4, anyone can already, and that includes any member of the legislature, any member of the public, can request an agency modify or repeal a rule for any reason at any time. So if even a member of the public thinks this rule is it goes beyond their statutory authority, they can request a change. They are obligated, an agency is obligated to respond to that in writing within 90 days. So there's a lot of mechanisms and enforcement and coverage in place to make sure agencies aren't going beyond the scope of their authority when they promulgate administrative rules. That was probably longer than I intended to speak, but I'm happy to answer any questions.
Thank you very much. Representative Groda?
Thank you. I think one of the difficulties might be when in legislation we give rulemaking authority to a commissioner or an agency without any guardrails. And so can you address that and how that can be managed within our bill writing capability?
Absolutely. Thank you for the question. I think it's a good question. And if you remember last January, I came and presented to ED&A and we presented to the GELCAR. And one of the things I really wanted to harp on, and then this, I sort of addressed it in my comment, but the legislature has those controls. So when you see language that says the agency shall adopt rules to effectuate this chapter, extremely broad language. If you say the agency shall adopt rules as necessary to make this section work, this chapter work, very, very broad language. So in that case, the legislature may be giving more authority than they even intended. Maybe not. I don't know. That's a policy decision. But if that does seem to be the case, the legislature can come back and modify that rule writing authority and put guardrails on that, and you already have the ability to do so. So if that authority's out there, if you think an agency is going above and beyond what you really intended, you get another bite at that apple and you can modify that authority.
Thank you. Yes, Representative Schmidt.
Thank you, Madam Chair. So, in your testimony, Representative Potenza referenced the federal government and so forth, but the supremacy clause says that in the areas of the federal government's authority, they have the power to create laws and to enforce those laws. They can't do it. The 10th Amendment, everybody knows, but within the scope of their constitutional authority, they do that, and even that goes through the JLCAR, and the reference is either in the U.S. Constitution or sometimes 28A or something like that. But as a 20-year member of the JLCAR, I've seen this happen. I've also seen situations where there was no authority. The smoking ban in restaurants and bars, for example, had an administrative penalty, a fine of $50 for which there was no authority in the statute, and that was immediately flagged by the JLCAR, by the attorneys first and then by us, and so forth. And we went back and gave the agency authority because no hammer, no compliance, right? So thank you. Maybe you can speak to that.
So the supremacy clause, I think that's a really good point, and I'm glad you asked this question, Representative. And one of my concerns, and this is addressed a little bit in my written testimony, is that maybe the language in this bill could be a bit too narrow. And I am worried that if we limit the rule writing authority specifically to the RSAs, we might bump up against sort of the constitutionality of this, right? Because you're talking about the supremacy clause, Article 6, Section 2 of the Constitution. Representative Lynn gave a little talk on the supremacy clause far better than I could at a recent JLCAR meeting, but I think you nailed it on the head, right? And what we do is when it comes through, every rule that comes through is going to have state authority, or where it's appropriate, it might have federal statutory or regulatory authority, but we do the same rule regardless, or same review regardless. So if a rule comes through us, whether that authority comes from the state, whether it comes from the feds, we're still doing that analysis to make sure the agency is acting within that authority granted to them by the legislature.
Thank you. Representative Sitek.
Mr. Osterhout, would you, you want the committee to believe you're testifying as a matter of information, right? Or are you against? You didn't say.
I think if the bill goes from a policy decision, I think we're already doing a lot of what the bill is intending to do. I think the mechanisms for enforcement are already, and for checking, are already in place. If the committee decides to move forward from a policy decision, I'd like to be involved in helping with drafting some of the language to make sure that it works within the systems we have. But as far as I absolutely believe that we need to make sure an agency doesn't act outside of the scope of their authority. My entire job is to do that review to make sure they act within the parameters designated to them.
I'll put you down for information only.
Sounds good. Oh, my goodness. What a question. Yes, information only. Yes, sir.
This is a question, actually a comment disguised as a question. You may not answer this, but why does it take 13 months, 16 months for a rule change? Come on.
So typically, all right, that's a fair question. And I also think the OPLC is a bit extraordinary. So if you were going to go to HHS, DES, some of the other agencies today, if you were really on the ball, filed things, and you could probably have it done, assuming you didn't use an expedited process, within 3 months. Typically we see 3 to 6 months, right? And then they're modifying the rules based on public comment. I think where the OPLC bumps up is that they also have to work with the boards, and some of these boards don't meet except for once a month or once every 3 months. And so their timelines are a little bit different than most state agencies.
Thank you. I do have a question about the new function that's in the bill that we heard earlier today, where if a agency loses rulemaking authority, those rules become invalid. If we were to remove the and as necessary to implement this chapter, would that make invalid anything that does not point to a specific part of the statutes?
I think I would have to take a look at the actual language before I could answer that comfortably, right? It really depends on the language that's in front of me at the time. But you know, the agencies are they should be on top of these legislative changes, and they should be amending the rules to comport with statutes, be they new, be they amended, be they repealed, right? So that can take some finagling from the agency side. But I think that's a challenging question without actually having language in front of me.
And then I guess as a follow-up, that's something where when it's a challenging one, there would be a discussion in GELCAR about whether the rule is actually invalid or if it does have the statutory authority, so that then that can be challenged if we've added, you need to wear a water bucket on your head in order to do this because that's how an agency thought something needed to be implemented, but that was not supported by statute, correct?
Correct. If the GELCAR, right, it undergoes review, like we may say to the GELCAR, we don't think the agency has the statutory authority. And when it comes to the committee, that's the conversation you all would have. And then there's, GELCAR is not a policy committee, but there are limited grounds for which you can object to a rule. And one of the big ones, obviously, is lacking statutory authority or going beyond the scope. So if the committee had that discussion and said, we think this rule goes beyond the scope, we could postpone the rule, give the agency a chance to revamp it, or we could object to the rule and then the agency would be obligated to provide an answer. But absolutely, yes.
Thank you. Representative Sitek, is there, then Representative DeRoy, I didn't see her. Yes, we'll recognize you first.
Are there any parameters audits that are being done with these agencies once we make a law and a rule goes out that they have to follow it?
The LBA actually conducts audits on agencies, and part of their, I don't want to speak too much for the LBA because it's sort of a separate function within the office, but one thing they do, I've been on the other end of an LBA audit, and one of the things they do is a review of the statutes, a review of the rules, and then they will flag anything, or they, more often than not, what I've seen is the agency needs to promulgate rules in response to statute, not so much that they have rules that don't have statutory authority backing them up.
Thank you.
So the short answer is yes, the LBA will do an audit of an agency.
Thank you.
Yes.
Thank you. Representative Sitek?
It's been a very long time since I was an alternate on GELCAR. But the question I have is how many times, can you give us a feel for how many times GELCAR has issued a rule over a final objection? How often does that happen?
How many times has an agency adopted a rule over a final objection? Those are far and few between. It's not happened in my tenure. I'm not aware of it. Hold on one second. 2019. What was it? The Learn Everywhere rules received an objection from the GELCAR, and then the agency adopted them over the objection.
2019.
2019.
Oh, okay.
It does not happen often. It's a very scary thing. And the other thing, if you file a rule or you adopt a rule over the objection of the GELCAR, it changes the burden of proof in court. So if the GELCAR approves a rule, and this is probably getting too specific, but if GELCAR approves a rule, it has presumptive validity in court. If the agency adopts over, the agency has the burden of proof to show that's a valid rule, and it's a much more difficult burden to meet.
Thanks a lot.
Thank you. Are there other questions from the committee? Seeing none, thank you very much. Next, I'll call up Executive Director DeGiorgis.
I have her called here somewhere.
Good afternoon. For the record, DeGiorgis, Executive Director, OPLC. I typically like to speak without the screen in front of me, but I did pull up, while you were speaking, I have a timeline from my rules coordinator, kind of just a hypothetical. If a board voted to initiate rulemaking on X date, here's all of the dates that we would get through to get to final proposal. So I'm happy to reference that into if anyone would like to pose the question again about, my gosh, 13 months, that's so long. Happy to get into that with you. I would just say as a an agency, OPLC, is responsible for providing rulemaking support for all the boards that are under that umbrella. And associated professions, some of which there does not have a governing board for. So we're up to 61 professions. That means that the office does about 20 to 25% of the state's rulemaking. So sitting before you is a quarter of the rulemaking that comes through the office. So happy to speak to that experience. So just to reiterate, Director Osterhout did mention about the 90 days. I do think that time frame would be I don't think that would be logistically possible. So not speculating on the wisdom of this review or not, but can say we regularly, I can think of 3 off the top of my head where we have rule proposals that come back flagged from attorneys saying, you don't have authority to do this. Like, you need to take it out of your rules. Like, they won't even go before the committee. And part of the office's responsibility is to bring that message to the board and say, you don't have authority to do this. You need to pull it out. Sometimes that then prompts requests to put things in statute to give them authority. And then that gives this committee most often, and the legislature the opportunity to say yes or no, we want that to happen. And sometimes it's a long-standing rule that gets flagged to say, gosh, they really never had authority to do that. And then we have to decide, the legislature decides, is that something we want to do? A good example of that is we looked at this last year. This committee worked while we moved a bill really quickly to provide statutory authority for licensing LNAs within the first year of a nursing program. So that was a long-standing practice that had been set in rule for some time that really had no legislative authority. But stakeholders and the legislature all said, we really want that to happen. And so that was a case of us saying to you, hey, we don't have any, they've identified we don't have any authority, but everybody thinks this is a good policy idea. Let's put it in law so that this practice can go on. We had halted it so that it can restart. So that's a good example of that check and balance. It happens regularly. Probably almost every proposal, I would say. There's something that's flagged. So the attorneys are working hard, sometimes to our annoyance, I would say. We almost never get a proposal back with no comments. So they're doing a thorough review, so I will just speak to that. And then, like I said, happy to talk through timeline or answer any other questions you all have.
Thank you. Could you tell us a little more about that timeline?
Yes, sure thing. So I won't, genuinely, it's a page and a half of single line bullets. So I won't go through all of that. I will skip through. So I have a number of timing, like basically specific with the boards, right? It's a lot more interaction because they have to review. A board only has authority as a body. So they can review outside of a meeting, but decisions can't be made on the fly. It has to be made as an entity. So if we skip through the period of time where the board says, hey, I want to do this, and then we prioritize it, and then we actually draft something, because sometimes that can be quite extensive. So we'll kind of skip out those that 4-month timeline, we'll say, just for the sake of this. So it goes on the agenda. Again, we're thinking if it goes on the agenda in May for a board review, they have up to 90 days to review, edit, and approve the initial draft proposal. So that's current policy within our office, but it's to say, like, we want to make sure they get it right. Again, they can only act as a body. So sometimes they might need several meetings to get that together. So that's 90 days. So that would put them to August. They approve their initial proposal for filing. They set the date for the public hearing. We need, per RSA 541A 6 and 7, we need we get up to 21 days to get the fiscal impact statement back. So then if they take the full 21 days, they don't always, then we're into September 18th, the rules published in the rulemaking register. From that time when it's published, the initial proposal, we have 180 days to get the final proposal in. So then there's a bunch of things in between: public hearing, public comment. Public comments are summarized. We have to come up with a description of every single public comment and how the agency or board either adjusted the rule in response to that comment or the specific policy reason why they didn't. So that takes a lot of time. The board has to review all of those. Then the rule drafter has 30 days to draft a final proposal. They get it before the board. So that means we have to file before March. We also have attorneys for the board that have to review it. A draft final proposal would be submitted sometime around December, perhaps so the following January. Remember, they voted to say we want to make rules the previous January, and here we are. They're going to meet to discuss the final proposal. They have 60 days to approve it. So we say internally, you can't just sit on this forever because we have these statutory deadlines. We file the final proposal in March, and then JLCAR hears it at their next scheduled meeting.
That is
And
quite a
that's with it
process.
going well. That's no JLCAR objection. Yes, that's with things going well.
Thank you.
Yes.
Representative Sitek?
Meanwhile, everyone's retired.
In this hearing?
May I write, is it okay with you if I write for information on your card?
Certainly.
All right, thanks.
I can fill that in for you yes.
Thank you. Are there other questions from the committee? Seeing none, thank you very
Thank you, Mom.
much. Is there anybody else here to speak on House Bill 1683? Seeing none, I will close the hearing on House Bill 1683, and we have 5 minutes until we open the next hearing. It being 2:15, I will open the hearing on House Bill 1211 relative to the scope of review of state agency interpretations and call up Representative Kofalt.
Thank you, Madam Chair. Thank you, members of the committee. For the record, my name is Jim Kofalt, State Representative from Hillsborough County, District 32, representing the towns of Wilton, Temple, and New Ipswich. House Bill 1211, relative to the scope of review of state agency interpretations, ensures that our state courts exercise independent judgment when reviewing state agency actions. So by way of background, there is a doctrine, or there was a doctrine known as the Chevron deference that that originated in 1984 in a U.S. Supreme Court case, Chevron USA Inc. versus Natural Resources Defense Council. And in that case, the Supreme Court essentially said that if there is a federal regulation, in other words, if a federal agency enacts a regulation, that the courts are to defer provided that it is reasonable. So if the statute authorizing the rule is ambiguous, or if if there is question as to the interpretation of the statute, the Chevron deference dictated that the courts would defer to the agency's interpretation. So that granted pretty broad latitude to agencies and disempowered those who would challenge agency rules. So all of that changed in 2024 in a case known as Loper-Bright. Loper-Bright Enterprises versus Raimondo, and this had to do with federal fishing regulations and agency requirements that fishing vessels would actually have to fund the inspectors that would ride along on those vessels. And in that, the Supreme Court overruled the Chevron deference. So this was a landmark case. It really changed the way administrative rules, or in this case, federal regulations, are viewed by the courts, and essentially said that courts should interpret those regulations de novo. So they should exercise independent judgment. So in that ruling, Chief Justice Roberts wrote that the Administrative Procedure Act requires courts to use their independent judgment on questions of law, and that this restores the judiciary's constitutional obligation to interpret the law. House Bill 1211 brings that same principle to New Hampshire. It codifies that principle, aligning New Hampshire with the current state of the law in the United States. So in this case, again, we're talking about administrative rules at the state level rather than federal regulations at the federal level. The bill essentially just amends RSA 541A to require that de novo review. And this promotes additional accountability, and it aligns us, as I said, with federal, with current federal policy. And it shifts the balance of power to, the judiciary and ultimately the people's representatives. So that's where this gives the people a stronger voice in the governance in our state. I also want to highlight, I actually have a proposed amendment in hand, which I would like to offer the committee for your consideration. Because after some discussions with judges, members of the judiciary branch here in New Hampshire, it was pointed out that there are what are known as the canons of interpretation, and some of these are codified in New Hampshire statute. So this essentially, and I will provide a copy for the clerk along with my written testimony, but essentially what this would do is it would mirror that same language that you see before you in a different section of statute, RSA 21. It would insert a new section that simply says presumption of liberty in administrative law. consistent with RSA 541A 24A, which is the proposed revision that you already have before you. In actions brought by or against state agencies after applying all customary tools of interpretation, a court or hearing officer shall resolve any remaining doubt as to legal meaning in favor of a reasonable interpretation that limits agency power and maximizes individual liberty. And so essentially this is us codifying the state motto, live free or die, the ethic that I think brought many of us to love and cherish New Hampshire and make it our home. So again, I will provide a copy of that language to the clerk and would respectfully ask the committee to consider adding that language. That ends my testimony, and with that, I'll take any questions.
Thank you. Are there questions from the committee? Representative Sitek?
Representative Kofod, you're not objecting to a particular rule, administrative rule. You're questioning how it was interpreted in a particular case. The gas station was too close to it didn't follow a rule or something. You're not talking about the rule itself. You're talking about how it was applied in a particular case. Is that what I understand this to be?
Correct. This creates a legal framework and offers the judiciary a clearer, let's say, clearer guidance as to that they should be making a de novo interpretation rather than deferring to agency interpretation. So it would apply across any court decision where somebody brings a legal action against an agency, or where the agency brings legal action and the court is required to interpret rule.
Thank you. Representative Pearson?
Thank you, Madam Chair. Thank you, Representative, for fielding questions. In the first part here, it talks about interpreting its meaning without a state agency's interpretation. Could a judge use the Attorney General's office as an example for interpretation? Could a judge use their own technical experts that they bring in, especially if a matter is technical to the point where they lack the knowledge in the subject matter?
Thank you for the question. So there are some people coming after me who I think have much deeper legal experience and can better answer that question. I would say fundamentally the intention is that the courts should not simply defer to the agency's interpretation, but should make a de novo interpretation based on any of the factors that may be brought before them.
Thank you. I have a question for you if my interpretation of this is correct. To me, this says that if it goes to court, they just start from scratch, take a look at what's going on, and if there's a tie in their decision making, they're not deferring to the agency, but the tie goes to the people. Is that a general way to look at this?
That is an accurate way to look at this, and particularly the Roman numeral II portion of it, yes.
Thank you. Are there other questions from the committee? Seeing none, thank you very much.
Thank you.
And next, I will call up Sarah Scott.
All right. Thank you, Madam Chair and members of the committee, for the opportunity to testify here again today. My name is Sarah Scott, and I'm the Deputy State Director for Americans for Prosperity here in New Hampshire. I will preface this by saying I'm not a lawyer, so I'll do my best here, but we do have somebody with some legal expertise coming after me. Ultimately, Americans for Prosperity believes that government should be accountable to the legislature, the legislators here, and when the courts are making a judicial decision, they should be deferring to what the legislature's intent for those rules was. At its core, this bill is really about a simple but powerful principle that laws should mean what the legislature says they mean, not what an agency determines they mean later on. We think that this bill restores balance. It ensures that when the law is unclear, decision makers have a clear understanding of applying traditional tools of interpretation. And when doubt remains, resolve it in favor of the individual and protecting individual liberties rather than expanded agency power. This isn't an abstract legal issue. For a lot of small business owners, this uncertainty can mean delays in hiring or expansion. For families, it could mean given unexpected compliance costs. So we saw this case firsthand here in New Hampshire. Representative Kofalt mentioned the case with the fishermen. Prior to the Loper Bright case being filed, there was actually a court case brought by some fishermen from New Hampshire regarding this issue. So I would say that was kind of came before the Loper Bright case here. So this was something that was obviously dealt with from the federal level, not the state level. But we've seen precedents here in the state that it's something that we need to address. And I think that this gives us a good opportunity moving forward, where right now we might have agencies that are correctly interpreting the laws as the legislature has written them, but this really protects us for the future. And so we don't know what the future might hold with heads of agencies, but we want to ensure that they are still held accountable to those same things that the legislature intended there today. So this bill ultimately strengthens due process. It reinforces legislative authority and protects Granite Staters from regulatory overreach. So we would ask that you support the legislation. Happy to answer questions if they're not about the legal basis of this.
Thank you. Are there questions from the committee? Seeing none, thank you very much. Next, I'll call up Sam Gardlin from the Department of Justice.
Thank you, Madam Chair, and thank you to the committee for allowing me to testify. So I think, though I checked off opposed on the pink slip, we are largely not opposing anything that you've heard today from the sponsor of the bill or from Americans for Prosperity. As I read Roman numeral 1 of the bill, it's designed to do effectively what Loper Bright did, which would be to eradicate something akin to Chevron deference from interpretive principles in New Hampshire. I will say that the New Hampshire Supreme Court, to the best of my knowledge, hasn't ever adopted Chevron deference. I think it's recognized that there's a tension in its jurisprudence with respect to how much deference to give agencies, and I think Roman numeral 1 would add clarity, and so we're not opposing Roman numeral 1 at all. So I don't want to suggest that I'm here in opposition of the bill entirely or the concepts behind it. Our concerns really flow from Roman numeral 2, and I think they're competing concerns or maybe nested concerns. The first is that, as currently written, I'm not sure Roman numeral 2 is actually accomplishing something that doesn't already exist in the law. There's a doctrine, and many of you are probably aware of it, so forgive me if I'm treading old ground, but a doctrine called the constitutional doubt doctrine or the constitutional avoidance doctrine. It's a canon of construction that the New Hampshire Supreme Court uses all the time. Federal courts use it as well. And it basically is the tie goes to the individual doctrine. It's if you have two competing interpretations of the law and you have one interpretation that brings tension to an enumerated individual liberty protected by our Constitution, protected by the federal Constitution, you don't adopt that interpretation. You should not interpret a statute, even if it could be reasonably interpreted in that way, to come into tension with individual rights. And so that's a well-established doctrine that exists in the jurisprudence. There are rules that surround it. I've litigated cases where it's applied. We've argued it on behalf of agencies to try to avoid conflicts with individual rights. And so I think that there may be something that's a bit redundant about Roman 2 as written, because it's already really reflected as one of those canons of construction that courts do. And if you take the thumb off the scales for kind of a Chevron deference doctrine, it would have greater effect, right? It would be really a tie going to the individual for these specific enumerated protections that our Bill of Rights has, that the federal Bill of Rights has. My concern that flows from that is if it's only designed to do that, but there isn't something that's clear that's really enshrining that in the rules of interpretation that are reflected in 541A and RSA 21, then it may create some unintended consequences in terms of confusing judges, confusing members of the public, confusing agencies in terms of how to apply agency interpretations of statutes and regulations. Because, and I don't think this will be news to anyone on this committee, courts have had a really hard time figuring out first, are there any unenumerated individual liberties protected by the Constitution? And if you believe that there are, what are they, right? I mean, there are tens and tens and tens and tens of thousands of pages of judicial opinions that are on that specific question. And so if the conception of individual liberty as written into Roman numeral 2 is something that goes beyond the doctrine of constitutional avoidance, or if it's not clear that it's really not doing going beyond that. I fear that you're going to get a lot of actually competing interpretations of individual rights and individual liberties that are based on individual judges' conceptions of them, as opposed to, the text of the statute, the text of the Constitution, the original meaning of the Constitution. And I think that might bring some uncertainty to the jurisprudence, as opposed to the stability that the bill is designed to accomplish. I think, too, that there are instances where conceptions of individual liberty, if they're not tethered to constitutional rights, may be in tension with one another. And they may well be with constitutional rights as well. A kind of classic example that I don't think you have to have gone to law school to think about is the classic example of the First Amendment doesn't protect a person saying fire in a crowded theater, right? There are limits to that. But certainly the person who wants to say that would say that not being allowed to is a constraint on their individual liberty. Oh, I'm sorry. Wrong bill. I think you would have an argument that the folks who are in the theater who want to watch a movie with it unimpeded would say that it's a constraint on their individual liberty to have to leave if a person were to yell fire. I think a business owner who owns the theater might well say it's a constraint on his or her individual liberty to not be able to turn a profit making, selling movie tickets, right? And so obviously that's a pretty abstract example. It's probably not something that's going to come up that often, but when you have competing conceptions of individual liberty and judges really have to strike a balance or break the tie, I'm not sure Roman numeral II is really doing something that constitutional avoidance doesn't already do. And so I'm not opposed to the bill at all. Our office isn't opposed to it. I'm not opposed to the concept that's within the bill, but I am concerned that Roman II would have some unintended consequences that may actually run counter to what it's designed to accomplish. I'm certainly happy to work with the bill sponsors and to work with the committee on addressing those concerns. Though I do think that if the law were to go forward with just Roman numeral I, it would be accomplishing, at least in substantial part, if not entirely, what the sponsor of the bill identified being the purpose. I welcome questions. Thank you.
Thank you very much. Thank you. Representative Long?
So I have a constitutional avoidance question about Roman numeral II that's a little bit different than what you've raised, which is that not every lawsuit against the state or a state agency is brought by an individual. So does existing constitutional avoidance doctrine address what happens when it's, say, a municipal government or a federal government agency suing the state, and there might be implications for individual liberty?
I'm going to give you a probably frustrating attorney response to that. It does, but it depends, right? I mean, so the constitutional avoidance doctrine isn't limited just to lawsuits brought by individuals trying to invoke rights that are enumerated in the Constitution. It certainly would apply to creating constitutional problems in terms of the structure of the government, whether that's vis-a-vis the federal government and the state and the state government and local governments. But what I would say with respect to that is that I think that highlights part of my concern with respect to Roman II in terms of competing constitutional interests, because it is true, I think, as a matter of constitutional interpretation that municipal governments, for instance, do not have rights that are enumerated in the Bill of Rights. But people may well have rights vis-a-vis municipal governments, vis-a-vis the state government, vis-a-vis the federal government that are in conflict with each other if the state and the municipalities don't agree on how certain regulation might apply. And I think too, you might well have, especially in the municipal context, in the land use context, places where you have two pretty obvious, maybe even constitutional interests, like property interests, for instance, that would be protected by the Constitution that are in tension. Abutting landowners sue each other all the time, and they certainly have certain protected rights. And so I think that actually highlights some of my concern about Roman II as written, is that there are a number of layers to it that could create unintended consequences.
Thank you. Did you have a follow-up or are you?
No.
Okay. Thank you. Are there other questions? Sorry. There we go. Representative Pearson.
Thank you, Madam Chair, and I'll go back to what I asked the sponsor here, where in section 1 it says may not defer. May not defer. Let's work on the word defer. Does that mean they can't even look at their interpretation? It's prohibited? Does it mean it can't become the primary driver? What does may not defer mean?
So if you look to the Loper Bright decision. May not defer does not mean you can't look at an agency interpretation. And that means, and by agency interpretation, to just clarify a question that you asked, I think to Representative Kohlfalt, that isn't me going into court and defending an agency. It's actually the underlying agency interpretation, right? So Loper Bright says you don't have to disregard that, but you can't have it place a thumb on the scales. It basically, you have to do the judicial function and interpret the statute using the normal rules of construction from start, right? So it's not that you have to turn blinders to it, but it certainly shouldn't be a deciding factor or even really, as I understand it, a thumb on the scales in any way. It may well be that the agency interpretation is a very good interpretation of the law, and a judge is able to, using the rules of construction, independently come to that and believes it's the right interpretation. But it's the judge's responsibility to come to that conclusion, not the agency's responsibility to tell the judge that that's the right answer.
Follow up. Thank you for that. That helps a lot. And then I guess that brings me to what I had asked before about judges then in technical matters where they're trying to decipher what they're looking at. Under this, would they have the ability to bring in experts if they needed them for technical things? Can they bring in the opinion of the Attorney General's office? Can they bring in, because they're not the agency, they're an agency, but they're not the agency in question. So would they be restricted in that regard, or is that just wide open for them?
So I'll take the Attorney General's office first, probably because it's the place where I have the most expertise. I like to think, and you can judge for yourselves based on my testimony today, but I like to think that when I go into court, I'm helpful to judges to understand the issues that are before them, right? That's part of what my job is when I represent an agency. I don't read the bill, and I would have even graver concerns if the bill were intended to do this, that it would limit our ability to do that, to go in and represent to a court, here's what we believe is the correct interpretation of this statute, of this regulation, and how the case should be resolved based on that interpretation. Because in that capacity, I don't understand our office to be making an independent agency interpretation of the kind that Chevron considered, but rather advocating on behalf of a client's interests, clients that include the legislative branch, right? We represent all branches of government. In terms of experts, that's a thornier question, because for the most part, experts aren't supposed to be opining on the correct interpretation of law to begin with. There are rules of evidence and doctrines around that basically say judges are supposed to make that interpretation, and so you weren't supposed to defer to an expert anyway. There are very thorny, highly technical cases where a judge may think that those lines get blurred, right? Having an agency person come in and talk about the implementation of a regulation may well be fact testimony. It's how we've interpreted it and how we've implemented it, and we're an expert in doing that. And so they might be able to testify to it, and the judge can consider, the factual testimony, but it still shouldn't supplant the judge's own interpretation of the law based on his or her belief of what the answer to that question is based on the normal rules of construction.
Thank you, Representative Schmidt.
Thank you, Madam Chair. So first, I as you can see, I'm somewhat hard of hearing, and you didn't say your name. The chair announced you, but you did not say your name. So would you say it again so that I can reflect it in my notes?
I will. I apologize. My name's Sam Garland. I'm a senior assistant attorney general at the Department of Justice.
Very, very good. So may I ask my question now? So is it not the case, and I'm very attentive to Representative Pearson's question and to this issue because, as I said in my earlier remarks on an earlier bill, judges get overruled all the time on appeal, and sometimes the appeal court will be remanded by the Supreme Court as well. So the idea that just because a court ruled that way means that's eternally correct is simply not the case. And it seems to me like in terms of deferring to the agency, that very often the court decision will say that they make it clear they are deferring to the agency, and this bill says don't do that. Which because that kind of sweeps the BLT from the table and says we're going to start all over again, we're going to do what the agency says. And I like this bill saying that the court should take up the matter de novo.
So I have a couple of responses to that, Madam Chair. I think the first response with respect to overturning other decisions is that does happen all the time. It probably, I think, I don't know the statistics off the top of my head, but my understanding is it's the better than 90% of cases are not overturned on appeal, either because they're not appealed or the trial court got it right. But there are instances, and certainly in questions of statutory interpretation, they can come up where a panel of 5 justices or a panel of 3, U.S. Court of Appeals judges can say we disagree with the interpretation that our learned colleague in the lower court came up with. I don't think this is going to change that, right? I mean, I think that really just reflects that the act of judging can be difficult, and sometimes the already established rules of construction can point in different directions and reasonable minds can differ. And it's really why we have the appellate process. So I'm not sure this is going to change that all that much. What I will say about agency deference, which goes back kind of to what the first part of my testimony concerned, the New Hampshire Supreme Court has said that agencies can be, in certain circumstances, entitled to deference. But it's made clear that that deference has limits, and you don't defer to an agency if a statute's clear. So you don't agree with an agency if you think the statute clearly goes the other way. And the court has already said, as part of its jurisprudence, that we analyze statutes de novo. We are the final arbiter of what the laws that you folks pass mean, right? And then they've recognized that they haven't always been consistent in exactly how they've applied that doctrine. I think, like I said, they've used the word tension to describe their jurisprudence. But my understanding, as I read those cases, is we don't live in a state where Chevron pervades. It is a different form of deference. It's a one that judges are already doing more of what this bill would be designed to accomplish. And what I think the first paragraph of this bill does accomplish is it makes clear. It really will help clarify some of the tension that exists in the law as it currently stands. It says we're going to align ourselves with what the federal courts are doing now. Judges, you are responsible in the first instance for interpreting laws, and you're doing so de novo. And sure, you might be able to consider, as Representative Pearson was asking about, what an agency says, but you can't have that put a thumb on the scales, and you certainly don't get to say, well, they said it, so I'm going to adopt it.
Thank you. I have my first question for you is, you heard about the language that Representative Kofalt said maybe that he would like to introduce to us as an amendment. Is that something that you've reviewed, that language, and is something that would be acceptable?
So what I haven't reviewed it. Understanding what Representative Kofalt said today, it would be that paragraph 2, which is the one I have concerns about, would go into RSA 21, which is the statute that generally applies or generally contains the rules of construction. So my concerns would be the same. It's not that the concept shouldn't be embodied in the code anywhere. It's really how Roman numeral 2 is operating, and maybe some of the unintended consequences, I think, would be true in RSA 21 the same way they would be in RSA 541A. I don't have any problem, though, with whatever the final result of this bill is going into RSA 21, because 541A is the Administrative Procedure Act. It's limited to specific cases that involve agency action, but they're not the only sorts of cases that arise that involve interpretations of statutes or where an agency is the plaintiff or a defendant. And RSA 21 is the general statutory construction standards or chapter. So if whatever the legislature decides to pass makes its way into 21, I will have the same concerns that I have about the current language in Roman 2, but not that it ends up in 21 along with 541A.
Thank you. And that brings me to my second question. I'm not a lawyer and I wouldn't even try and play one on TV. But I feel like I've heard some rulings where they sort of couch one particular thing, saying that in this particular case, this is something that is this individual liberty is something where in this case it prevails. However, in other situations, there may be another competing interest. Is that something that happens and something that can happen when you have one of these potential conflicts? Because this isn't a baseball game. You might have two people running at the same base. And how do you choose between those two people?
It does. It does happen, yes. I mean, there are certainly cases where you're talking about enumerated constitutional rights where there can be a tension between rights that exist in the Constitution. I mean, the classic example of it, right, is a tension in the First Amendment to the Constitution between establishment of religion and free exercise. That's a perennial challenge, is trying to strike a balance between those two concepts that are embedded right there in the text of the First Amendment. But you see it quite a bit too with homeowners' rights versus Second Amendment rights. You might see it with respect to student or teacher rights and parental rights. I mean, it comes up all the time, and courts have certain tools for for resolving those already. I mean, the rules of construction do that. I can't say that it comes out perfectly or always perfectly predictably, because the law can be hard, right? It's not as clear cut as it might be when it's not as clear cut in a given case as it might be in the abstract. But what I would say is that that's something that courts are already doing, and I'm not sure that this bill, other than kind of eliminating any concept of Chevron, would really be changing or simplifying that process. And my fear is actually Roman II would be complicating it, because it would be injecting different conceptions of individual liberty that really go beyond the enumerated rights in the Constitution into the discussion that could lay claim to people and honestly judges coming down very different ways on very similar questions.
Thank you. And so clarifying that, if it were instead to read something along the lines of the court or hearing officer shall exercise any remaining doubt between an agency and an individual in favor of a reasonable interpretation that limits the agency power and it maximizes the individual liberty, because then you're focused on the particular runner as opposed to who else is running towards that base? Or am I making it even more complicated?
I don't think you're making it more complicated. I think that what that fails to appreciate is that there can be cases that there are multiple runners that have competing interests, individual runners, that in a given case. So there certainly can be the example that I think you were asking about, Madam Chair, that is, you have this case, how it gets resolved in this case, but it might go differently in a different case if there were some other interests that were implicated. But we certainly face cases, and I'm going to fail to give you an example off the top of my head sitting here, but I can certainly think about it, that there are multiple individuals in a given case whose rights are in conflict, or at least in tension in that case. And how does a court resolve that? Courts still have to do that. They do it all the time. But does this actually complicate that resolution? Because now a court's saying, okay, we have an agency interpretation, we have an individual interpretation, we have another individual interpretation. We won't do the agency interpretation unless maybe it maximizes individual liberty. But how do we pick between those two other competing individual interpretations? That's going to be a tough task. And I fear that as written, the bill does probably beg more questions than it answers on that particular context.
Thank you. Representative Slotchi?
Thank you, Madam Chair, and thanks for taking my question. The interpretation of liberty, I think I see what you're getting at with the interpretation of Roman II, and the immediate comparison that jumped into my head is the conception of liberty in the American Revolution versus the French Revolution, and they used the same terminology, but those interpretations were very different. Is that a fair way, in your estimation, to view the tension that arises from the use of this language?
I think so. It's the uncertainty in terms of what the bill is referring to as individual liberty, whether it's just individual liberty as basically codified and enumerated in our Constitution through kind of the American conception of it, or if it's some broader, more abstract concept. And I can tell you that litigants are very enterprising, and that could be people represented by counsel, people who aren't represented by counsel, who have very firmly held, and I think legitimate beliefs about the extent of their own individual liberty that may or may not be consistent with kind of the constitutional conception or the founding conception of individual liberty. And when you don't have the term in the statute tethered to a specific kind of legal hook, that I think is what creates the problem I'm concerned about.
Thank you. Representative Pearson?
I'm going to throw a PhD level question at you, but do you believe that a person's individual liberty ends when it affects another person's individual liberty?
So that is a PhD level question. I can't say that I can answer that question. This is going to be very much a lawyer answer, and I apologize for that. That's something that courts have been grappling with in our country, and honestly, philosophers and others have been grappling with for a lot longer than our country's been around, from the very beginning, right? I mean, the U.S. reports, the United Supreme Court Reporter, is full of instances of that sort of tension, and it's really where some of these doctrines of construction come up from, which is to basically, as part of the social contract, you're giving up some amount of pure liberty, right? Like the ability to do whatever you want, whenever you want, in order to kind of exist in a society with other people who are also kind of coming to that same agreement. I think generally speaking, people are fine with that. But when the rubber hits the road, is like, here's the specific line between my interest and your interest. And so I don't know the answer to it. I mean, I think The direct answer to
I
your
don't
question.
expect a direct answer to that question because you would PhD level
Yeah.
answer. But what I'm getting at with that is that not the crux of the problem with Section 2 here?
It's my concern with Section 2. And I think the answer I would give you is that at least the U.S. Supreme Court has said, yes, there is a limit. And I'll go back to my fire in a crowded theater example. Individual liberty, absolute free speech would, I think, support the notion that you should be able to do that. You should be able to go into a room, or at least it's covered by that concept. But the free speech doctrine recognizes that there is a limit to that concept when it too directly affects the interests or rights or safety of others, right? It's a robust protection. I'm not trying to suggest that I can go in the court and limit it, right? But there is a threshold at which it's no longer protected, and that is really the concern that I have here, is that the conception in here is not really bounded by those constitutional standards.
Thank you. A JD answer to a PhD question. We appreciate that. And that is the crux of the matter. So thank you. Are there any other questions from the committee? Thank you. This has been very valuable.
I would just reiterate that I'm here to help. So if there are specific technical questions or we can assist, and if the sponsors of the bill, including Representative Colfault, want to talk, we're here to help. We're not trying to torpedo the bill. We're trying to provide some help.
Thank you. And since we're so conveniently located to the Department of Justice, if we have work sessions or subcommittees, will you try and make yourself available for those?
Certainly. And you know where to find me, I think.
Perfect.
All right.
Thank
Thanks
you so much. And next I'll call Jamie Kavanaugh, please.
Thank you, Madam Chair, members of the committee. My name is Jamie Kavanaugh. I'm an attorney with Pacific Legal Foundation. Pacific Legal Foundation is a public interest nonprofit that works to protect everyday Americans' rights, both in courthouses and in state houses. I'm here today testifying in support of House Bill 1211. It's a simple bill to end judicial deference and end the practice of courts deferring to agency interpretations of their own authority. This reform is extremely important to ensure that courts are fulfilling their constitutional duty to independently interpret the law. By passing this legislation, New Hampshire would be joining a growing movement of states committed to protecting individual liberties and the rule of law. This isn't a full list. You can find a full list at statedeference.org, statedeference.org, but some of the states who have used statute to remove judicial deference are Arizona, Idaho, Indiana, Kentucky, Tennessee, and Texas. And I think just, to step back for a second, most Americans are shocked to learn about the practice of judicial deference, right? If they haven't heard of this, if they aren't in the legal community, allowing courts to act, or instead of allowing courts to act as neutral arbiters, the doctrine requires courts to place a thumb on the scale in favor of government. That's kind of, the antithesis of what an everyday American would think the role of the court is. So we're really just helping the judiciary restore its proper role in interpreting the law and listening to arguments from both sides, from the agencies, from the individuals who are affected. We're not saying you can't hear the argument of the agency or you can't hear their explanation for what they were doing, but when you go to interpret what the law actually says, you don't weight the agency's argument more favorably than you would weight the individual's argument. This practice, as PLF has documented, undermines accountability and has led to regulatory overreach. It has chilled economic freedom and leads to violations of private property rights. So this bill takes a critical step towards safeguarding individual freedoms, promoting good governance, and upholding the rule of law in New Hampshire, and PLF urges this committee to support this bill.
Thank you. Are there questions from the committee? I have a question for you. It sounds like in New Hampshire, there's already sort of that leaning towards the deference that's closer to this interpretation. But without having a statute, there's the possibility for the judicial process to move over time and move to the process that now is not accepted under federal law, but still, because states are separate entities, there's still the potential for this to slide over towards that side of the deference if we were not to have this in statute. Is that correct?
That's correct. That's absolutely right. Pacific Legal Foundation thinks it's best practice to codify the end of judicial deference for exactly that reason. Courts can change their mind over time. A lot of states, New Hampshire included, as we just heard, they have a tension in the doctrine where maybe some courts in the past have been more deferential. Courts today maybe might not be quite as deferential, but really to clarify for everyone what the standard is the best practice.
Thank you. And as a follow-up, doing that while the process of the courts is more in line with this type of policy is better than waiting until it may be in a conflict.
Absolutely.
Is that something you would say?
That'd be asking to maybe overrule more cases. This would be just keeping with what New Hampshire seems to mostly be doing and ensuring that the courts continue best practices.
Thank you. Are there other questions from the committee? Seeing none, thank you very much. I appreciate you coming. Is there anybody else here to speak on House Bill 1211? Seeing none, I will close that hearing. We're just ahead of 3 o'clock. We did a lot of work yesterday, and I think we should be happy with all those bills that we've been able to do. We have had executive sessions on 17 bills, 2 of which are going to the regular. No, I went through. It's actually 17 that we have reported out. And I think you have that as well in your numbers. But 16 to 17. So a very solid number of our bills. We have heard, according to this file folder, 52 of our 60 bills. We have several early bills that we will be working on next week in order to make sure that we're able to meet our deadlines. We'll be looking at the illicit human trafficking bills on Monday, and then we have a work session of all of our remaining early bills to look at on Wednesday as we're meeting, so we can have more of a discussion before we need to take final action on those early bills when we meet on February 11th. Those of you who are working on solutions to these and more of an ad hoc thing, I appreciate that. And I look forward to us continuing to do the rest of this business. And I appreciate everybody who was here today. And with that, we will close our day.